said tell you that she let the AM clerk with too. Okay? Huh?
Are those popcorn?
I think so. If you want them, you can have them.
Thank you.
Hi.
Hi, how are you, Judge?
Nice. How are you?
Good, thank you.
All right, good afternoon, everybody. You're in First Appearance Magistrate Court. My name is Judge Kim Teresa Malika. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say or do can and will be used against you. You also have a right to an attorney. We have Mr. Romero at the main jail, and we have Mr. Goldberg, who I believe is going to be with us momentarily. If you have a private attorney, please let me know when you step up to the podium. Mr. Romero, let's start with this while we're waiting for Mr. Goldberg. Do we have any Spanish interpreter cases?
Let me make that announcement. Alguien solamente habla español. ¿Qué es su nombre? Alonso qué? There's a gentleman, Alonso Guerrera, Judge. Let me try and locate where he is on the docket. Alonso Guerrera. Second look? Okay, so let me look at the second look. Guerrera.
G or C?
It's page 14, Herrera.
Herrera.
Herrera? Con un H o qué? Oh, Herrera. Herrera.
That's what Kifa said.
Second.
Alonso Herrera Hidalgo.
Oh, Hidalgo.
Okay, anybody else you need? Look at the second look docket, maybe?
Toma asiento ahí, necesito hablar contigo. ¿Alguien más solamente habla español? That's the only gentleman here at Main Judge.
Okay. All right, so we'll have, let me ask, North Broward, anybody need an interpreter, please?
No, ma'am, we're fine, thank you.
Anybody at Conti need an interpreter?
No interpreter.
Thank you.
But you did give me a green light to mention if I only had one person.
Okay, who's that one person?
He's on the.
Don't bring him out yet because we got to do one. We have a special prosecutor here, and then we have the Spanish interpreter. If not, we'll take yours. What's the person's name?
He's on the 30-day Kit Ingemar. Thank you, ma'am.
Okay. That's what? Oh, all right. Bring them out fast. We'll just do them quickly.
Great. Thank you very much.
You're welcome. Have a great weekend.
Yeah.
Okay, are you Mr. Ingemar?
Yes, ma'am.
All right, it's my understanding that your attorneys filed a motion to have you released because the state hadn't filed charges timely. So
Yes, ma'am.
that doesn't mean that they can't file them in the future. State, did you file charges on Mr. Ingemar? All right, so sir, you're entitled to be released on your own recognizance. What charges are these?
Thank you, ma'am.
Hold on, I want to finish telling you something. Hold on.
Okay.
Does anybody know what page he is? I'm sorry.
He's on the 30 docket, Judge? Or the second one?
Second look, that's right. Felony. Ingamar, I-N-G.
Yes, ma'am. EMAR.
I don't have him on this one. Not on mine. Oh, yes, it is. That is his first name. His last name is Keat. He's on page 2 of the felony docket. Okay, so you were charged with possession of controlled substance and riding a bike with no, looks like lamp or lights. So you're going to be ROR'd. The state has not filed charges. That does not mean, sir, that the state can't file charges in the future. So
Yes,
it's your
ma'am.
responsibility to keep the clerk up to date with your address, with this case number of this case. So you're going to be ROR'd today if you don't have anything else pending. Thank you and good luck to you, okay?
Have a nice day.
You too. Have a nice weekend.
Thank you, ma'am.
This one.
The main jail has been calling me about Malcolm Wilder on the top of page 6. I can't physically tell the courtroom whether
Sure. Okay, who is this?
Malcolm Wilder on the top of page 6.
We'll get there eventually, I promise, State. Herrera, I'm sorry, Malcolm.
Wilder, yep.
Got him right here. Okay. Okay, Mr. Malcolm Wilder. Come on up, sir.
He's approaching, Judge.
All right, Mr. Wilder, you have resisting without violence. There's a $500 bond. Does he want to resolve the case today?
He does, Judge.
Is he capable of resolving the case today?
He is. He's just
Okay, I
feeling a
just
little
wanted to make,
indisposed,
I
that's all.
understand. I just wanted to make sure. I didn't want to force him to do something. Okay, State, do you have an offer?
Judge,
It's-
I don't have a PC on this case. It's resisting without, we'll defer to the court.
Okay. What's his priors like, Kifa? Anything of sum and substance?
Just trespass, or is this, another trespass, 2015?
Okay, withholding court costs.
He wishes to accept the court's offer, Judge.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, is your name Malcolm Wilder, W-I-L-D-E-R?
Yes.
All right, you can put your hand down. It's my understanding through your attorney, Mr. Romero, want to resolve your case today and plead no contest or guilty to resisting without violence?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
Okay, guys, can you just try to keep it down just a little bit, please? All right, sir, so you said you wanted to plead no contest?
Yes, ma'am.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea, withhold of adjudication, court costs of $293, 6 months to pay. Partial payments are accepted. If you don't pay it, sir, they'll suspend your driver's license, $25 late fee, and it'll affect your credit. Okay, so make sure you pay that $293. You can pay at any of the 4 courthouses or online, or send in a check with your case number. Court takes judicial notice of a time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Good luck, sir.
All right, so can you call up for a Spanish interpreter?
What's the name of the defendant?
Alonzo Herrera Hidalgo. Okay, let's call Talisa Mullins. Thank you for your patience.
Good afternoon, Alexandra Buckle on behalf of the state.
Spell your last name.
Buckelew.
B-U-C-K.
Elew.
Okay. Thank you. Sorry about that.
No problem.
Okay, so where is Talisa Mullins? Is that her?
You're present, main judge.
All right, Miss Mullins, you are charged with a home invasion. See, you got to correct me. I'm looking at the warrant to arrest. It says home invasion robbery, but my cover sheet over here says home invasion with firearm or other deadly weapon.
Correct, Judge. We did an amended probable cause affidavit, which I did provide to Your Honor as well,
Okay.
indicating that it is armed because the 3 people that she helped get into the home were armed with firearms at the time.
Okay, all right, thank you. I just wanted that for clarification.
No problem.
All right, so as of now, ma'am, there's a no bond hold. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim in the case. And what do those initials state?
It's AD.
Okay, and no victim contact, direct or indirect, and I want everybody to listen up what this means in the jail. No victim contact, direct or indirect, means no contact in person, calling, texting, writing, nothing whatsoever on social media, including liking, disliking anything. And it also includes not passing messages through third parties to the alleged victim in the case. And Ms. Mullins, in your case, it's the alleged victim has the initials AKD, and the court is going to order no return to (1051) Southwest 39th Ave, Fort Lauderdale. If you go back there, you'll be arrested. What say you, State?
Judge, I have one more request.
Sure.
I'm asking that the defendant be kept separate from certain inmates. I know they are males, but when they're being brought up to court, they are sometimes commingled. The inmates that I would ask that should be kept separate from are Nicholas Clive Lewis, BCCN 26621.
Let me ask you a question. I've never been asked to do that before, and I don't mind. But is that something that you've done before?
Yes, Judge.
Okay, I just wanted to make sure.
And I did show the defense a copy of this before I started reading it into the record.
Okay, stay away from Nicholas.
Clive Lewis.
CLIVELEWIS?
Yes, Judge. I do have the order already typed out.
Oh, okay. Just give me their names. If you want to bring it up for me.
Sure.
This way I can just write it on my face sheet. Thank you so much. Okay. Okay, and what are you seeking? A finding of proof, evident, presumption, grade, or bond?
Proof, evident, presumption, great, Your Honor.
Okay. All right, defense.
Judge, initially, just as to the matter of counsel, initially, Ms. Mullings advised us that she had retained private attorney Clark Strandell. I believe Madam State spoke with Mr. Strandell and was advised that Mr. Strandell had not been retained but is set to meet with the family next week. Ms. Mullings' mother is in the courtroom this afternoon. I believe that information is correct, so Ms. Mullings did make an application to the public defender this afternoon. Judge, as to proof, evident, presumption, great, and probable cause, I've read the warrant. I don't think I have an objection. There is really no information here beyond some text messages back and forth that tie Ms. Mullings to the robbery. I don't have an objection to probable cause, but to hold her as a principal to a home invasion robbery, an admittedly serious crime, we would object to a finding of proof, evident, presumption, great. It appears that there's nothing except text messages that tie her to this incident at all, and as a matter of fact, she at one point was listed as a victim of that same robbery. The warrant is pretty lengthy. I'm sure that an appropriate Arthur hearing needs to be done in depth, but to hold her no bond at this time, that would be over defense objection. If the court is going to find proof evident based upon this lengthy warrant, I would still ask that you use your discretion, which is afforded to the court, to set a bond, and I'd like to hear if you'd be open to that, and then I would defer to Mr. Romero to populate that further. Additionally, her mom is in the courtroom if you need to take testimony as to ties to the community.
Okay. All right, so State, what's your response, and then we'll discuss it further, Mr.
Judge, not only in this case was she originally a victim, because when the police showed up, she was there in the house with AD, the victim in this case, but the cell phone for one of the co-conspirators that committed the armed robbery, who had a firearm, who is a known violent criminal in this community, who has multiple cases pending at this moment, left his cell phone by accident on scene. She was observed trying to hide that cell phone with her foot while on scene. The phone was recovered. We did subpoenas, we did warrants, we found out who that number belonged to, and all of the text messages show that she was to leave the door open for those men to come in. She basically lured AD back into his house for these men to come in with guns and rob him, which they did. We also, Your Honor, just for the court's edification, she was arrested last night prior to actually committing another home invasion, which we have tons of jail calls for, in which she was collecting firearms and working with other convicted felons as well to commit more home invasions. She has continuously gotten more violent, more involved with these crimes that are being committed, and that was just the start. So we're asking that proof evident presumption great be found based on the text messages and her involvement in luring AD into the house, but so that the court understands the whole situation going on here. This is an organized gang of sorts that is committing these crimes and continuing to commit these crimes.
Judge, if I can respond. You know, obviously, Judge, I'm asking you not to find PEPG on this case, but if you do find so, I'd ask that it be based strictly on the material that's presented to the court. Any other either ongoing activity or future activity, those allegations are not before the court. There's a single count of a home invasion robbery which occurred December 6th, 2017. I would object if the court would consider any of that outstanding material that's not substantiated or presented before the court. There's no charges that I'm aware of.
I'll give it the weight that it deserves. But aside from that, you know, what's going on with other matters, you know, and I'll just give you a couple, and this is just based on a couple things. It says Lewis and Mullings talk and discuss the surveillance of the target. If she gets a new, Mullins asks Lewis if she gets a new phone and provides Lewis with another number. And then they have additional conversations about the job site. They talk about $40,000 in her hand. So I have reviewed the warrant to arrest, and I do find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're going to be held without bond pending further order of the court. This order is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Ma'am, you're charged with some very serious crimes. So you have the right to remain silent. Anything you say or do can and will be used against you, and Mr. Romero or your attorney will advise you further. So court's going to order no victim contact, direct or indirect, with the alleged victim with the initials AKD. You are not to return to 1051 Southwest 39th Avenue, Fort Lauderdale, Florida. I know you have no bond, but I don't know if the charge is going to change or what's going to happen. And you are to stay away from, defendant is to be kept separate and apart from inmate Nicholas Clive Lewis, BCCN number 2666. Looks like 21, inmate Eric Hunter, BCCN 803033. Inmate Willie Barnwell, BCCN 733844, and inmate David Fletcher, BCCN 109822. Thank you very much. Good luck to you, and good luck to you, ma'am. Thank you. Let me just write their names here.
It's at Southeast 7th, right off of Federal Highway.
Okay, who's going to give a copy of this to the jail? Thank you. Nice meeting you.
Sorry, Casey, this is
How long have you lived in South Florida?
Okay. All right, we have the Spanish interpreter here. If you could come up, raise your right hand. Do you swear and/or affirm to translate from English to Spanish, Spanish to English to the best of your ability?
Yes, I do, Your Honor. Theodore Leal, Leal spelled L-E-A-L for the record.
Okay. Mr. Alonso Hidalgo.
Judge, he's approaching and he declined the service of the public defender.
All right, Mr. Hidalgo, good morning, sir.
Buenos días, señor.
Buenos días.
Good morning.
Mr. Hidalgo, you understand that you have a right to an attorney?
Señor Hidalgo, usted entiende que usted tiene derecho a un abogado.
And if you
Sí.
can't afford an attorney, we'll appoint the public defender for
Y si usted
purposes
no
of
tiene
today.
cómo pagar un abogado, se le designaría a un abogado público.
You also have the right to represent yourself,
También tiene el derecho a representarse por sí mismo.
and you also have the right to hire your own attorney.
Y también tiene derecho a contratar su propio abogado particular.
Okay.
Yes.
If you want to hire your own attorney, we can reset this hearing for tomorrow morning,
Si usted
tomorrow
quiere
afternoon, or Sunday.
contratar a su abogado, podemos entonces reprogramar esta audiencia y podría ser para mañana en la mañana, podría ser para el domingo.
So tell me, sir, would you like me to appoint the public defender for purposes of today?
Señor, entonces dígame, ¿quiere que le designe un abogado público, defensor de oficio para propósitos del día de hoy?
Do you want to represent
¿O se quiere
yourself,
representar a sí mismo?
or do you want time to hire an attorney?
¿O quiere que le den tiempo para que contrate un abogado privado?
¿Yo puedo responder por mí mismo?
I can represent myself.
Okay, Mr. Hidalgo, you are charged with, what page is this?
It's on page 14.
Okay, if you could go to 14.
Thank you. Very well, Your Honor. Página 14.
Okay, you have it?
Yes, Your Honor. Thank you.
Okay, Mr. Hidalgo, you have battery on an officer, firefighter, EMT.
Física a un representante de la ley o de servicio de emergencia.
We need to talk about bond,
Tenemos que hablar de fianza, entonces.
possession of cocaine, $1,000 bond,
$1,000 de fianza por la tenencia de cocaína.
drug paraphernalia, possess and or use, $100 bond,
$100 por adminículos o útiles para el uso de la droga.
Okay.
resisting an officer with, or obstructing without violence, $100 bond,
$100 por oponerse resistencia o obstruir el labor de un oficial sin violencia.
battery on an officer, firefighter, EMT,
Y una agresión física en contra de un oficial o representante de servicios de emergencia.
So your total bond is $1,200 on counts 2, 3, and 4.
Son $1,200 en los cargos 2, cargo 3 y cargo 4.
We're going to hear from the state attorney what they're requesting on counts 1 and 5.
Y vamos a ver qué dice la
2,000
fiscalía.
on each count.
$2,000 por cada uno de esos cargos, el 1 y el 5, $2,000 más.
Would the court inquire as to his ties to the community as far as where he lives and how long he's lived there?
Vamos a preguntar qué vínculos tiene con la comunidad, si la corte quiere preguntar.
Okay. Did you hear that, sir?
¿Tiene vínculos con la comunidad? ¿Escuchó usted en cuanto a trabajo, dirección, lo que hace aquí?
So the state attorney is
La
requesting
fiscalía.
$10,000 on count 1,
Pide $10,000 en el cargo 1.
2,000.
No,
2,000
$2,000.
on each. 2,000 on one and 2,000 on count 5.
Perdón, 2,000 en el cargo 1 y 2,000 en el cargo 5.
okay, so I thought you said 10,000, I'm sorry.
10,000,
That's
perdón,
okay.
perdón.
Okay, so you want 2,000 on count 1 and 2,000 on count 5.
2,000 cargo
Yes, Your
5.
Honor.
So 2, 4, 5. $5,200 total.
El total son entonces $5,200 de fianza.
Okay.
Can
¿Ok?
you afford that, sir? Can you afford 10%?
¿Usted va a poder pagar el 10% de eso, señor?
Hoy no puedo porque no tengo comunicación con ningún familiar y no puedo hablarles.
Today I won't be able to. Perdón.
Is there
Sorry.
anybody that we can call to try to bond you out?
Sorry, Your Honor, the interpreter got cut off, choked a little bit there.
That's okay.
Did
Must be
say,
something over in that side of the room over there,
Yeah.
seriously. Go ahead.
Not today. Today I'm not able to communicate with any relatives.
Okay. Okay, is there any relatives that someone could call for you to try to bond you out?
¿Tiene familiares a quien puedan alguien llamar para que le saque lo saque bajo fianza?
No tengo familiares, no tengo.
I don't have relatives.
¿Perdón?
Mr. Romero,
Señor
let
Romero.
me ask you a question. Have you spoken at all to Mr. Hidalgo?
¿Usted habló con el señor Hidalgo, señor Romero?
No, Judge. When he declined, I didn't speak to him any
No
further.
hablé con él.
State, do we have any prior cases with Mr. Hidalgo?
Vamos a revisar si hay casos anteriores.
Do
¿Tiene
you
un
know if the
caso
public
de-
defender has represented him previously?
Para eso representó a la Defensoría Pública anteriormente. Un caso ese de dejar el lugar de
I'm
los
just
hechos.
having a little bit of a concern.
Es que algo que me preocupa un poco.
That was a Palm Beach County case,
Eso
right?
fue en
It
Palm
was.
Beach. No, en Broward, no fue en Broward.
Another Broward case that was withheld.
Caso que fue fallo mínimo.
Okay, sir, is there
Señor.
anybody who would bond you out of jail?
Señor, ¿quién le podría pagar a usted, quién lo sacaría a usted bajo fianza de la cárcel? ¿Quién le pagaría?
Tengo una persona que tal vez me prestaría el dinero, pero no
I have
estoy
a
seguro.
person that may lend me the money.
Okay, who are they?
¿Quién es la persona? ¿Quiénes son?
Do you have their number?
¿Tiene el número de teléfono de ellos?
No, no tengo nada. Los teléfonos tenía, pero es que antes que me arrestaran los oficiales, me asaltaron y me quitaron lo que yo traía, bicicleta, todas las cosas de mi trabajo.
No, the things I had it, but
Y el teléfono.
before my being arrested, I had just been robbed. I had my bike. They stole my bike. They stole everything I had, everything that I had for my work.
Okay, you're not being responsive to my question, so can you listen to my question carefully,
Escucha la
sir?
pregunta cuidadosamente para que responda directamente a la pregunta.
Do you have any friend who you can give me their name and telephone number, and we could have someone call them to see if they would loan you money to bond out of jail?
Señor, si usted tiene un amigo, nos da su nombre y el número de teléfono de ese amigo para que alguien aquí pueda darle una llamada para que esa persona le pueda entonces prestar el dinero para que pueda salir de la cárcel.
You're welcome.
Nada más tengo el nombre, pero el número de teléfono no me lo sé. Estaba registrado en mi teléfono.
I got the name, but I don't know the phone number. The number was in my phone.
And where's your phone?
¿Y dónde está su teléfono?
Mi teléfono me lo robaron junto con mis cosas cuando yo.
Yeah, when they stole all my things, it was stolen as well.
What's his prior history state?
Vamos a ver qué antecedentes tiene. Con la
Thank you,
familia.
Mr. Romero.
Gracias, señor Romero. ¿Qué
What's his
pregunta?
prior history?
Antecedentes. Lo único, el lugar de los hechos de un accidente en 2018.
Is that case resolved?
¿Se resolvió? Sí, ese caso ya se resolvió.
Mr. Dressler, I'm thinking about
Señor Tres,
putting him on a GPS level 2.
pienso ponerlo con un GPS.
They're gonna have to verify his
nivel
address.
2, pero hay que verificar la dirección de él.
Do you have anything else for him, or?
¿Algo más para él?
Sir, what's your address, where you
Señor,
live?
¿cuál es su dirección donde usted vive?
509 Southwest,
509 Southwest. 509 Southwest.
Segunda Court.
Second Court.
Ajá.
Ciudad.
Apartment number 3?
Oh, apartamento, perdón.
Número 3.
I don't know. Your
He
apartment.
just said numero tres, didn't he?
¿Cuál es el número del apartamento?
3.
Oh, 3. You're right. You're
Okay.
Spanish very much.
How
right.
long has he lived at that location?
¿Hace cuánto tiempo que vive usted en ese lugar?
Año y medio.
A year and a half.
And that's in Pompano Beach?
¿Eso en Pompano Beach?
Sí.
Yes.
Who do you live there with?
¿Con quién vive usted ahí?
La persona que está ahí es mi primo.
The person there is my cousin.
And what's your cousin's telephone number?
¿Y cuál es el número de teléfono de su primo?
Eso es lo que no tengo yo, los números de teléfono, disculpe.
I'm sorry, but that's what I do not have, the phone numbers.
Okay, Mr. Dressler.
Judge, I'm concerned about the battery Leo charges,
Ocupan los cargos
combination with the drug charge.
de ataque combinado con drogas, el cargo de droga.
Okay, sir, this is what I'm gonna do.
Esto es lo que vamos a hacer, señor. Esto es lo que va a hacer el juez, señor.
You're saying you can't afford any bond right now because you don't have any numbers to call anybody.
Usted dice que no puede pagar fianza ahora porque no tiene los números para llamar a nadie.
You don't have any access to numbers because someone stole your phone.
Y alguien le robó el teléfono, así que usted no tiene ya acceso a esos números.
So the only thing that can happen is you can sit in jail,
Lo único que puede pasar es que usted se quede esperando ahí en la cárcel,
or I can put you on an ankle monitor,
o yo le puedo poner un monitor de tobillera, un grillete.
and
Sí,
you're going to have to give them a schedule
Y tendrá que darles un horario, su horario,
and show them that a schedule of where you're going to be.
y darles a ellos, mostrarles los horarios de dónde va a estar usted.
ok.
If you violate, you'll be back here on a no bond hold, I assure you.
Y si usted viola esos acuerdos, usted va a regresar otra vez acá, se lo aseguro, y sin derecho a fianza.
But they're going to have to verify your address and go to your house
Pero ellos tienen que verificar su dirección, ir a su casa
and talk to your cousin
y hablar con su primo
and get information from him that you're allowed to live there.
y obtener información de su primo de que a usted sí se le permite vivir ahí.
What is the best?
¿Puedo decir,
Go ahead.
perdón, ¿puedo decir algo más?
Can I say something else?
Sure, don't talk about the facts of your case.
Seguro, pero no hable de los hechos de su caso.
No, es que yo tengo a mi esposa ahí en la casa, pero ella no tiene dinero porque yo nada más trabajo.
Yeah, I got my wife home, but she doesn't have any money because I'm the only one that works.
Yo tengo 2 bebés ahí, están chiquitos.
I got dos bebés?
Sí, de
Yeah, I
3
got 2
años,
babies and they're very
4
little. They're very small.
He has what?
Dijo que tiene 2 bebés, ¿no?
No, I didn't hear what you said.
Oh, 2 babies, but they're very small.
I thought he said he lives with his cousin.
Pensé que usted ha dicho que usted viviera con su primo.
Sí, es un departamento de 2 cuartos.
It's a 2-bedroom apartment.
So you mentioned your cousin before your wife?
Pero usted mencionó primero a su primo antes que mencionara a su esposa.
Sí, porque es que ella no tiene dinero.
Yes, because she doesn't have any money.
All right, this is what I'm going to do. Someone's going to go to the house.
Alguien va a ir a la casa.
I'm going to give you a curfew from 8 p.m.
Le voy a dar un límite de horarios, un toque de queda de 8 p.m.
to 5 a.m.
a las 5 a.m. El toque de queda.
Okay?
Bien.
Someone's going to have to verify your address,
Alguien tendrá que verificar su
whether
dirección
it be your wife or
con su esposa
your
o con su
cousin,
primo,
that you're allowed to live
de
there.
que usted sí se le permite vivir ahí.
Good luck to you, sir.
Suerte para usted, señor.
No bond required.
No más se requiere, no requiere fianza.
Okay, I don't think we need a Spanish interpreter. Thank you so much. Have a great weekend.
You do, Your Honor.
Nobody else, right, Mr. Romero?
No, Judge, no one else.
Okay. So that you're obviously going to have to do a field visit on. Okay, Gary Altman, please.
It's here, Judge.
Okay, Mr. Altman, we're back again. So you're still under oath. I want to make sure that, and I know you probably weren't feeling better before. I just want to make sure that you're doing this freely and voluntarily. I don't want you to feel like you're forced to do this, but I have to ask you certain questions, okay? Yes? All right. So you still want to keep your no contest plea to no ocean vest?
Yes.
All right. All right. The court's going to accept your no contest plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Adjudication, 5 days, credit for time served. $78 in court costs, 6 months to pay. Partial payments accepted, no return to 2600 West Atlantic Boulevard, Pompano Beach, Florida. Good luck to you, sir, okay?
Yes, ma'am.
You're welcome. Radislaw Skorzinski. I have defendant will come back. This is a medical loan, I think. Huh? I'm sorry, I can't hear you with this. It's impossible to hear. You're gonna have to speak into your mic, unless you want to yell.
I'm sorry, Judge, where are we right now on the docket?
Okay, it's from this morning,
Oh,
and I think the clerk gave this to me by accident. I have medical loan. Can someone tell me where Skurzinski, Skurzinski. His first name is Radislaw.
Judge, can we go off the record for a moment?
Sure.
I got you.
Adams, and I did find probable cause on that. I said just bring him back for bond. Okay, Mr. Adams,
He's here present, Judge, at Maine.
why did we reset this for the afternoon? Was this because someone's gonna have to speak into their mic? You have no idea. I can't hear one thing you say.
It was reset because there were some ad charges.
They're gonna add charge. He only had 2 cases, I believe, this morning,
Yes,
so now he has
14
14 cases, yeah.
14 charges or cases?
14
charges.
charges, I'm sorry.
No, that's okay. I just wanted to clarify. So does anybody have his booking sheet?
You have.
It was from this morning. I have the copy from this morning.
I have the copy from this morning with 2 charges. I never was given 4.
There should be checking your pile, Your Honor.
Okay. All right, Kiefer, why don't you come up and look and you tell me? We'll recall your case right back. Look in this pile, it's not here.
No problem. Recall?
Darren Adams, do you have it? The corrected booking sheet?
Yes, it should be 7 counts.
I would like it to attach it.
Yeah, we have ours. You get,
I'm good.
yeah.
Yeah.
Okay, so Mr. Darren Adams, this is what you're charged with. Count 1, 3, 4, 5, 6, 7, 8 are all $1,000 bonds. It's false owner info for pawn items less than 300. And then count 2 is dealing in stolen property, $3,500 bond. And that's also the same for counts 9, 10, 11, 12, 13, 14. So 14 total charges. $3,500 for the dealing in stolen property and $1,000 for the false owner info.
Yeah, if my math is correct, Judge, I believe he's being held on a $31,500 bond.
Okay, court finds probable cause. What say you?
Judge, unfortunately, Mr. Adams is not in a financial position to post that monetary bond. He lives with his father, and his father's retired, and from what he informed me, he does not believe his father can post that monetary bond. Mr. Adams has been living in our community his whole entire life. He's 38 years old. He's not a convicted felon, Judge. He does have stable employment. He's been working with the same company for the past 2 years. It's called Certified Professional Repair. He's basically repairs air conditioning units, refrigerators, things of that nature, Judge. He lives in Cole, like I said, with his father. Judge, we'd be asking, Your Honor, considering these are not violent charges, his strong ties to the community, I do not believe he's a fighter. He's going to be coming back to court, Judge. We'd ask you to consider releasing Mr. Adams on pre-trial.
Your Honor,
Yes.
he was just arrested on August 17th for a burglary, unoccupied dwelling, and a grand theft.
Wait, August 17th for what?
A burglary, unoccupied dwelling, unarmed, and a grand theft.
Is that this one?
No, it's a different, yeah.
What's the case number?
18-10044 CF10A. He bonded out on $1,000 on each count.
And grand theft?
burglary on occupied dwelling, and a grand theft, yes.
Can you do me a favor, Ivy, when, I'm gonna give you back your file so you can write on it for this gentleman. But, can you have Jackie, when she comes back, make a copy of this booking sheet for you, or maybe you can make one for us? Yeah, I want to attach it to the clerk's file so that we're clear. Okay.
Judge, considering the new information that had been apprised of, would Your Honor, rather than standard pretrial release, consider releasing Mr. Adams on level 2 with a monitor with an open schedule, Judge?
I'm honestly, I'm thinking of revoking his bond.
Judge, I don't believe the court could revoke his bond. I think the allegations on the case before the court today, there's several dates of incidents, all of which preceded.
That one?
Yes, Your Honor. Let me just verify. I don't want to
No, I
misrepresent
understand.
it. August 17th, correct. And all of these occurred
So
prior
it's
to
different
that.
date?
Yeah.
All
So
right, no problem, I understand.
obviously, the court can make a pretrial release determination, but I don't believe you can revoke his bond. Because there'd be
Judge,
no
it would
bond
appear from the
violation.
burglary probable cause affidavit that it would appear that the items that were pawned in the dealing in stolen property.
Came from this burglary?
It's possible because the incident dates are the same.
How? I don't believe that's correct.
On June. This is when they wrote it up.
Okay, I'm sorry.
The date of the alleged burglary was August 17th.
Is this post-dated or predated?
And,
This happened before.
and per the probable cause before the court,
This happened
the
in
date of the transactions are in June 13th, July 10th, July.
Yeah, it looks like
14th.
the dealing happened prior to the burglary. I stand corrected. At least according to probable cause affidavits.
All right, so this appears to be allegedly a separate incident.
Yeah.
That preceded the other matter.
What date did he bond out on the other one?
Okay, so go ahead, Mr. Romero. Start again if you want. I'm not putting him on, pretrial supervision.
Oh, that's why I withdrew that request, considering the new information, and that's why I was requesting Your Honor consider level 2 with the monitor, Judge.
Judge,
And
it
payment of no bonds at all?
Ju-
Hold on one
Let
second.
me inquire, Judge. Let me inquire.
Let me just find out if he has a bond.
Judge, he's informed me he has nothing right now at this moment, Judge.
Where's your client live?
He lives in Coral Springs, Judge.
What's his address?
2735 Northwest 86th Way, Cool Springs, Florida 33065.
Well, that's the address of the alleged victim. Let me read this PC again, hold on.
Tell you what the date of the pawns were. That he responded to them.
That's not where he lives, allegedly. It says that is, the victim states that Mr. Adams is his estranged 38-year-old son that broke into their residence. Okay, so go ahead, Mr. Dressler.
Judge, I don't have anything further. I've compared both of the probable cause affidavits. They look like incidents that occurred on different dates.
Judge, he did tell me he has other members of his family that live in his sister that lives in the same county, different city, Judge, and he believes he could go ahead and live there. He has no problem adhering to the condition of the court as far as no return to those premises, Judge.
Judge, given the number of pawns dealing in stolen property, we'd ask the court just to apply the standard bonds as set forth on the booking sheets.
Do you have the probable cause of the previous case, Your Honor?
No, I'm just looking at, I have it on the screen, but I'm just looking at this case. On 8/20, he pawned items. On 8/23, and he took a Winchester rifle and a Colt single action army revolver. And then on 8/23, he goes back with golf clubs. It just goes on and on and on. All right, anything further, Mr. Romero?
Just relying on my previous request, Judge.
All right, this is what I'm gonna do. 1,000 on 1, 1,000 on 2, 1,000 on 3, 1,000 on 4, 1,000 on 5, 1,000 on 6, 1,000 on 7, and then 1,000 on 8, 9, 10, 11, 12, 13, 14. I will do $250 bonds each.
How much, Judge?
$250. So from 1 through 8 is 1,000. 9 through 14 is $250. The only thing I might consider on a second look is if he wants to go to a rehab with a GPS, residential. Okay? So you're saying in the 18-10044 CF10A, Mr. Goldberg, I'm sorry, that the instant case was before?
Based on the information that I see, yes. That the dates of
Okay, that's fine. I understand. It appears. Not holding you to it. Okay, thank you. Oh, and sir, there's no return. Sir, can I have that back? There's no victim contact, direct or indirect, with the alleged victim in the case, who is WDA, and no return. And maintain 1,000 feet from that residence. Thank you. Theophil Omegat.
President Judge of Maine. Judge, we waive formal reading of the charge.
Did he make application this afternoon?
I'll have him do the application. Do an interview.
Okay, so Mr. Romero, waive formal reading.
Correct, Judge.
Okay, so we're going to appoint the public defender for magistrate purposes only.
Well, Judge, it would be our appointment. If he's indigent and qualifies, we'd be happy to represent him.
Okay, I just didn't know if he was getting a private attorney, so I just...
Yeah, that was the question, so.
He changed his mind. He wanted to go with the public defenders.
Okay. So I'll just put PD appointed, that's it. My paper looks like a mess, so. All right, so sir, you have one charge, case number 189869 CF10A. What say you, state? The court does find probable cause. Tacapius not in custody. And I don't have the initials of the alleged victim in this case. Do you have that, Mr.
Yes, I have it. We'd recommend a no bond hold, Judge.
What's the alleged victim's initials? Mine are redacted.
VO, Your Honor.
Bravo.
Judge, I'm not going to make any argument at this time.
Okay. All right, so Mr. Omegat, I have reviewed the probable cause affidavit filed in your case, and there's also a capias and the other documents in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, you're going to be held without bond until further order of the court. This order serves without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. You're going to be held no bond. I also am going to put, even though you can't bond out right now, no victim contact, direct or indirect, with the alleged victim, BO. And that means no contact in person, calling, texting, writing, nothing on social media, and no passing messages through third parties, even if you're in jail. Do you understand, sir? Okay.
You understand?
Thank you. Take that as an affirmative. Rolanda Garrett. Rolanda Garrett.
She's approaching, Judge.
Sure. Here you go. Hello, Miss Garrett. How are you? All right. You have an out-of-state hold for a felony. Bond set at $5,000 from out of the state of Texas for theft of property between $2,500 and $30,000. Court does find probable cause just for your arrest to hold you. We do have extradition court on Tuesdays and Thursdays at 1 p.m. So I don't know if you're on this Tuesday or Thursday or after that, but in any event, your bond is $5,000. If you can pay the $5,000 bond, you have to pay it before your extradition hearing in order to be able to bond out, okay? Thank you. Good luck to you. Elizabeth Anna Harker.
North Broward, Your Honor.
Sure.
I spoke with her and she'd like to resolve today if
Okay.
possible.
Good afternoon, Ms. Harker. How are you?
Good, thank you.
All right, you have petty theft, no-show, calendar call, Division MH, who is that? Judge Christopher Paul, and he did a $250 bond. The court does find probable cause. You want to resolve your case today, your attorney said?
Yes.
State, do you have an offer?
I don't have a notice, I don't have a probable cause affidavit yet.
Okay.
Yeah, never. They never found me with anything.
It's Ms. Harker, I wouldn't
Yes.
speak about the facts of the case at this time.
Okay.
But of course, you do not need to resolve this case today, as we discussed.
Yes, I understand, but I'm on disability, so I don't get my money until the 3rd. So I wouldn't know how to. I mean, I could try to bond out. I would like to plead not guilty because I'm not guilty of this crime. But I
Why'd
don't
you
want
fail
stay
to
in
show
jail.
up for court?
What happened is that I moved. I've had problems.
What's your
with
current
my-
address?
320 Walnut Street, apartment 2, Hollywood, Florida.
She doesn't want to plea, so.
But I don't want to stay here.
It was a bottle of wine.
Yeah. But,
Don't talk about the facts of your case, ma'am. I'm only speaking to them. I know
Thank you.
sometimes when I do talk about it, it invites conversation, but you don't want to talk about it, okay?
It was a
Thank you, ma'am.
theft of wine from Publix.
Judge, it looks like she was in the South Satellite Courthouse, and the matter was transferred to Central. And it was at that court date here in front of Judge Pohl in November of 2017 that she failed to appear.
All right, here's the thing, ma'am. You know, when you move, the clerk's office just doesn't magically find you and know that you moved. It's your responsibility when you move to notify your public defender, the court, or I should really say the clerk of court, and your attorney, if you have one with your case number, that you move with your new address. There's also other ways. You can call the public defender's office. You can always go online, browardclerk.org. You just can't miss your court date. So now...
I understand. I'm trying to get a care worker to help me with all of that because I also am on disability for mental issues. And right now, my primary and my psychiatrist are trying to get me a care worker so that way they could help me with these things that I seem to be having trouble with, like doctor's appointments and, just...
All right, well, here's the thing. You miss another court date, you're going to be back in jail, and then you're going to have done 3 days in jail for a charge that you want to fight. So show up to court or
I will.
Get the public defender's office, okay? So it's 320 Walnut Street, apartment 2, Hollywood?
Yes, ma'am. 33021.
Okay, based on her comments, Mr. Goldberg, you might want to track this case a little bit and maybe find out or have someone give a little bit attention.
Well, Judge, we don't presently represent her. I'm handling her matter today, but if she wants us to represent her, we'd be happy to do so. She just needs to make application to the court.
Okay, you need to make an application for the public defender. I thought they did today.
Not in North Broward, Your Honor.
Okay. All right, so you're going to have to go down to the public defender's office. It's here at the main courthouse.
Okay.
All right?
Can I get an ROR?
I'm going to give you an ROR, but you don't come back, you're going to get arrested again.
I won't. I haven't been arrested in 13 years. I don't want to ever go through this again.
Ma'am, I wouldn't speak any further right now, okay?
All right, good luck to you, ma'am.
Thank you. Thank you very much.
You're welcome. Show up for court. Jamie Gorney.
Main jail, Your Honor.
She's approaching, Judge.
Okay, Mr. Gorney, I thought they filled out an application at North Broward. I'm sorry, I didn't know that.
That's okay. We have an interviewer that's present in the main jail who's handling, because obviously the overwhelming majority, but for the other 3 interviewers are subsequently sent to those facilities. We don't have one kind of on standby the way that there's somebody present in the main jail.
Okay. All right, so Ms. Gorney, I'm sorry, you have distributor deliver heroin, $2,500 bond, count 2 is possession of fentanyl, $1,000 bond, count 3 is possession with intent to sell, manufacture, or deliver cocaine, $2,500 bond, count 4 is resist an officer, obstruct without violence, $100 bond. The court does find probable cause. What say you, defense?
Judge, nothing to add at this time. She advised me that she will be having a friend post her bond.
All right. Thank you. Oh, hold on. Let me just verify so I can be consistent here. 925 Northeast 4th Street, Hallandale.
That's your address.
Yeah.
Okay, thank you. Good luck to you. Virginia Garcia Oliveria.
Judge, can we go back on Ms. Goyne? I believe she said a change of opinion on something.
The bond, obviously. Well, he's doing that. Why don't we go to North Broward? Who do we have at North Broward? Give me one person while we're dealing with
We
someone.
got one coming in. What's your name? Mr. Johnson?
Okay, where is he, on the second look or the,
I believe
regular
that's Leonard
docket?
Johnson on page
Leonard?
6.
Page 6.
It's a municipal ordinance
How you
violation.
doing today?
All right, let me do him anyway.
How
All
you
right,
doing today?
good, how are you, Mr. Johnson?
All right.
All right, you have court in front of Judge Lerner Wren, September 6th at 2 p.m.
Yeah.
This
I
is,
couldn't show up because I gave the money. My mother, to give a letter to my mother saying I didn't show, so I didn't show. That's what it said in the letter.
all right, well, let me just tell you, this is for soliciting public without performance. You're in front of Judge Wren, so you're gonna have to wait until September 6th, which is a week from yesterday. Okay, so next Thursday, you'll see Judge Wren at 2 p.m., all right, sir?
Okay, can I go home today?
No, you're gonna have to wait till Judge Wren, unless you can post the $250 bond, sir.
Okay, how long is that?
It's gonna be a week, unfortunately. I know it's a municipal ordinance, but
Is that fresh? Okay.
okay, give me one moment, sir. Let's go back to the main jail. Okay, go ahead,
Yes,
Mr.
Judge.
Romero.
Judge, just a minute, Scorny, she's gonna be contacting her friend. She does not believe her friend can come up with the full amount. Her friend
Just
can
tell
probably
me
come
what
up
it
with-
is you're asking for.
Judge, I'm gonna be asking you to consider an outright ROR on counts 2 and 4. And on counts 1 and 3, I'm gonna ask for a bond reduction from instead of $2,500, $2,000 each, so that's gonna be a total $4,000 bond. She believes her friend can come up with the
Any
premium
objection,
$400.
state?
Yes, Judge, we would object to lowering the bond at all.
Okay,
Given the facts of the probable cause affidavit. She resisted the police in that they had to enter the bathroom where she was at. She wouldn't come out. They needed a SWAT team there. I would just object to any lowering of the bond.
what's
Judge, I
her
believe
prior,
the
what's her
last time-
prior, hold on, what's her prior history?
We're just showing a no valid DL.
This is what I'm gonna do, 2,000 on 1, 500 on 2, 1,000 on 3, 500 on 4. Thank you, good luck to you.
Thank you, Judge. And can we have a photo order, Judge?
Sure, as long as Mr. Goldberg wants to do one.
Perfect.
You need more orders?
Yeah. I'll have to get some.
We have some too. All right, Virginia Garcia Oliveira.
Ms. Garcia, come on up, please.
Hello, how are you?
Hello, ma'am.
All right, you have possession with intent to sell, manufacture, deliver heroin, $2,500 bond. Same thing for 2, but with cocaine, $2,500 bond. Count 3 is possession of methamphetamine, $1,000 bond. Count 4 is possession with intent to sell, manufacture, deliver alprazolam, which is also known as Xanax, $1,000 bond. Count 5 is possess and/or use drug paraphernalia, $100 bond. Count 6 is trafficking in oxycodone between 25 and 100 grams. Bond set at $500,000. Any objection to probable cause? Hearing no objection.
No.
Court does find probable cause for counts 1 through 6. Is your mailing address 50 East 35 East 35th Street, Hialeah, Florida? Is that your mailing address?
Yes.
All right, what say you, defense?
Judge, the only one I'm going to concentrate on is count number 6, which is a $500,000 bond. That's something that Ms. Garcia Oliveira cannot possibly afford. My understanding is she's 57 years old, been here her whole entire life at this time. She's unemployed. She's suffering from several physical ailments, and she told me she's going to be applying for disability. Having said that, Judge, she lives at that Hialeah home. She's been living there since 1979. She lives there with her mother and her brother. Her mother's on disability, and her brother is working. He works for a Napa Auto Store. He's a store manager there. So obviously that's the person she's going to be basically relying on to post her monetary bond. Besides that, she is a single mother. She has 2 adult kids, and both of them also she's going to be reaching out to help post her monetary bond. One of them works in the post office, and the other is a gentleman is a computer technician. Judge, we're going to ask on count 6 for a bond reduction from $500,000 to $35,000. I believe with the help of her 2 kids and her brother, they'll be able to come up with the bond on counts 1 through 6. My understanding, Judge, she has really no sort of financial assets, no sort of stocks or bonds. She does have a vehicle, but she's making monthly payments. It's a Nissan Altima 2016, which unfortunately her kids are helping her, are actually paying for the vehicle and paying about $100 a month for that vehicle. Judge, at this time, that is the nature of our request as to pertains to count 6.
Okay, State?
Judge, this subject has a 2001 burglary dwelling adjudication, 2014 petty theft withheld. Given the nature of the charges, we would ask the court to maintain the bonds as set forth on the booking report.
Judge, the only additional information I would like to share is I believe, yes, her main, most serious contact with the system was almost about 18 years ago, which she was placed on probation, and she successfully completed probation. So, Judge, it's not like she absconded or anything like that. She's going to come back to court. Just $500,000, just a bit much, Judge, to say the least.
Well, they said they found U.S. currency, but I don't see an amount. Oh, 1,078. I didn't see this last page. Hold on. What's the minimum mandatory on this? Is it 25 years or 15 years?
Judge, I'm gonna have to look at the statute to advise the court on that.
I believe it's 15, Judge.
Okay,
I
fine.
don't 100%.
That's
but I
fine, we'll
believe
take it
it's
as 15. All right, anything further from anybody? All right, GPS level 2. 2,500 on one. I'm gonna leave the bonds all in place except for count 6. Count 6, I am gonna do $125,000 in bond. Court does note that this is between 28 and 100 grams. Not that I'm lessening it at all. But the amount of grams found. Where is it again? 37 grams. So I'm going to make $125,000 on count 6, GPS level 2. Good luck to you. Pardon? No, I'll put her on all counts. Thank you.
Judge, can we get a 2-minute break?
Absolutely.
Okay, thank you.
Is Kayla Crossweight?
I've been informed, Judge, she bonded.
Bo David Littlejohn.
Mr. Littlejohn bonded.
Keep it going. Jose Sanchez.
Bonded.
All right. Travis Orr.
Mr. Orr, come on up. He's approaching you.
There you go. They're in order. Okay, Mr. Orr, good afternoon, sir. You have a touch or strike battery. $1,000 bond. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials KM. That means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. That's whether you're in jail or not. Court's also going to order no return, sir, to the Cafe H2O. Cafe, located at 101 South Fort Lauderdale Beach Boulevard, Fort Lauderdale, Florida. What say you, Mr. Romero?
Judge, I'm going to be requesting an outright ROR or at the minimum a pretrial release. I'll see if the state has an objection.
I'm also going to be requesting a photo order.
Sure. For what? Is it in state only, or? Violation of parole?
Parole violation. Case number. Let's see.
Where does he live? 1137 Northwest 16th Court?
Is that your address, sir? That is correct, Judge.
The only thing the court would be open to, based on the allegations, I know it's a misdemeanor, normally I wouldn't do it, but just based on what happened here, he was a former employee and he goes to the bar and it just goes on from there. I would do a GPS.
Let me talk to him about that. Judge, respectfully, thank you very much for your offer. We're going to be asking you for a phone order so that he can have access to his numbers and contact friends, come up with his bond, Judge. And also, as my colleague did state, we're going to request a photo order as well.
Okay, I'll grant your request for a photo order, $1,000 bond. State, you said he has a parole violation?
That's what it looks like, Your Honor, yes. This bond to confirm that this is still outstanding. That's all it says, Your Honor.
I think it's from Pennsylvania.
All right, thank you.
Thank you, Judge.
Tyree Lee?
He's approaching, Judge. Come on up, sir.
Okay, Mr. Lee, good afternoon. You have two capious traffic tickets, failure to register a vehicle and operating without a valid DL. No show at arraignment. Court does find probable cause. Want to resolve this case today?
He does, Judge.
State?
I don't have a driving record on him, Judge. I would just defer to the court.
All right. Withholding court costs, $293 in court costs on count one. I'll give him 6 months to pay it.
Yes, Judge.
Sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
All right. Is your name Tyree Lee?
Yes.
All right, Mr. Lee, you can put your hand down. It's my understanding you want to give up your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No.
How do you want to plead? Guilty, not guilty, no contest, failure to register a vehicle and operating without a valid license?
No contest, please.
Are you pleading no contest because you feel it's in your best interest?
Yes, ma'am.
All right, and you've had enough of time to talk to your attorney, Mr. Romero?
Yes.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, withhold of adjudication on each count. Court costs on count one only, $293, 6 months to pay. Court takes judicial notice of the time that Mr. Lee has served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying your $293. Thank you. Daniel Cole.
He's approaching, Judge. Come on up, sir.
Hello, Mr. Cole. All right, you have petty theft, second degree, first offense. Says all the money was recovered. It was a tip jar. No return to 209 Southwest 2nd Avenue, Fort Lauderdale, Florida, and no contact with Sarah Smith. And that includes the parking area and curtilage of the property. Do you understand? If you go back there, you will be arrested. You understand, sir?
Yes, ma'am.
All right, thank you. State, what's your offer? Is that what he wants to do?
That is correct, Judge.
Adjudication time served, Your Honor.
Adjudication, time served, $293, and no return.
Let me ask him.
Judge, he wishes to accept the state's offer.
Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes.
All right, your name is Daniel Cole, C-O-L-E?
Yes.
All right, put your hand down. Mr. Cole, it's my understanding through your attorney, Mr. Romero, you want to resolve your case today and give up your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
How do you want to plead to petty theft, second degree, first offense? Guilty, not guilty, no contest?
No contest.
All right, you understand that if you get 2 convictions for petty theft or a misdemeanor theft, upon the third one, it could be charged as a felony even though it's a misdemeanor. Do you understand that?
Yes, ma'am.
All right, and keeping that in mind, you still want to keep your plea of no contest?
Yes.
All right, thank you very much, sir. The court's going to adjudicate you guilty, time served you, $293. Accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. 6 months to pay the $293. Partial payments are accepted. No return to and no contact with Sarah Smith, 209 Southwest 2nd Ave, Fort Lauderdale, including the parking lot and curtilage. Thank you, sir. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Thank you. Javier Valdespino.
Bonded, Judge.
Oscar Morales, please.
He's approaching, Judge. He's here at me.
I'm going to have a PC objection.
Sure. Are you Oscar Morales, sir?
Yes, ma'am.
All right, sir. You are charged with DUI, alcohol or drugs, second offense, $1,000 bond. Count 2 is DUI, unlawful blood alcohol level greater than a .16. What say you, Mr. Goldberg?
Judge, I say that there's PC here for 1 DUI, not 2 DUIs. I think the court could find probable cause for count 1 or probable cause for count 2. I understand that they're not entirely subsumed, that there's a different element of his blood alcohol in count 2, but ultimately should this matter be filed and should it be sent to a jury or resolved through a plea, he could only be convicted of either count 1 or count 2. So, Judge, I would ask that you only find probable cause on either count 1 or count 2. In the alternative, Judge, if you are inclined to find probable cause on count 1 and count 2, that would be over defense objection, and I would ask that you ROR him on. It's a $1,000 bond either for both counts, so it really depends how the court would want to handle that.
Okay. All right. Respectfully, the court is going to find probable cause. Court is going to order no alcohol or intoxicants. Prescription medication is allowed as prescribed. What say you, Mr. Dressler?
Judge, we feel there's sufficient probable cause to maintain the bond on both counts. One as to the unlawful blood alcohol level and the other as to a DUI count. We routinely charge both.
Well, I did find probable cause already,
Yeah.
so thank you. Anything further? Just like to know, any special conditions? I did no alcohol, intoxicants.
Yeah.
Prescription medication allowed as prescribed.
Yeah, we just like to advise the court, he has a 2012 trafficking in oxycodone where he was adjudicated in a DUI with damage or injury in 2006.
What was his sentence in 2012?
3 years prison.
Okay, anything further, Mr. Romero?
Yes, Judge. Unfortunately, financially, he's basically living paycheck to paycheck. He works for a company called Ace Tech Transmission. He's been there employed for about 1 year now. He's 47 years old. As you heard, basically his DUI happened over 10 years ago. He lives in Fort Lauderdale. He rents a studio. He pays basically on a weekly basis. There's right now no one, from what he informed me, that can post his monetary bond. When he was arrested, he didn't have any funds on him to post any sort of monetary bond. So, Judge, I'm going to be asking for you to be releasing Mr. Morales on pretrial release.
Mr. Morales, how much money do you have in the bank?
None at all, man.
Do you have any stocks, bonds, or anything of value?
No, man.
All right, no alcohol or intoxicants, prescription meds allowed as prescribed, 1,000 on 1, ROR on 2. However, I am going to put him on standard pretrial supervision. And he's allowed medication as prescribed.
Thank you, Judge.
Thank you. Antoine Allen.
Who's that?
Antoine Allen, please.
One last request on Mr. Morales, a phone order, Judge?
Sure.
Thank you, Judge.
You're welcome.
Mr. Allen's bond was posted?
Okay, Mr. Allen bonded. Avindu Garbacia.
Mr. how do you pronounce your last name? Garbacea, Judge.
Okay, Mr. Garbacea, you have DUI, alcohol, or drugs. First offense, $500 bond. Count 2 is DUI, unlawful blood alcohol, greater than a .15. Court does find probable cause. I'll note Mr. Goldberg's objection from the last case.
It's the exact same situation as Mr. Morales, Judge. I'd object to finding a PC on both.
Okay.
We don't find any record on him, Judge.
Okay, what say you, Mr. Romero?
Judge, considering he has a clean record, he's a registered voter here in Broward County.
Tell me what it is you're asking for.
ROR, Judge.
What's his address?
1801 Southwest 23rd Street.
How long have you lived here?
I've lived there for like 40 years now. He's been in South Florida since 2006, Judge.
All right, this is what I'm going to do. No alcohol or intoxicants. Prescription meds allowed as prescribed. ROR.
Thank you, Your Honor. Mr. Romero, on Mr. Morales, was that a phone order or a photo order?
Phone.
Thank you, sir.
Thank you.
This last one I'm not putting on pretrial.
Just Mr. Morales.
Okay,
And the other gentleman, you said ROR.
thanks. Cornelius Watson?
Okay.
You could just throw him at me. Morales is at the main jail, okay. Okay, Cornelius Watson, good afternoon, sir. You have a host of ad charges. Let me go through them. Count 40 is grand theft between $300 and $5,000. Bond set at $1,000. Count 57 is grand theft auto, $1,000. Count 44 is burglary of a dwelling, structure, or conveyance. Armed, you have a no bond hold. Count 48 is the same thing, burglary, dwelling, structure, or conveyance armed. No bond hold. Counts 52 and 53 are burglary, unoccupied conveyance, unarmed. We have to talk about bond. And all the other counts, 40 through 60 are probation violations, and someone can correct me if I'm wrong, and they are all no bond holds?
Yes, Your Honor, they're all 948.
94806, okay. All right, thank you. And you are going before your division judge, Judge Coleman, on September 5th, which is this coming Wednesday at 8:30 a.m. Court finds probable cause.
Which I do have a PC objection on
Sure.
Mr. Watson.
Hopefully it's not to all counts.
It's not, but it is to all the new counts. I don't have any PC objection to the VOPs. So for the record, I'm objecting to PC on counts 40, 44, 48, 52, 53, and 57.
Okay,
So let's work through this together. This is quite
Sure.
a lengthy PC.
I don't even have a PC.
I believe count 44 and count
well, there's
40.
a lot of PCs. Do you have more than one? Because sometimes that happens with yours.
I only have one PC.
We don't even have a PC, Judge.
It was a reset from this morning. I'd be glad to
All
share
right,
with
you know
what I
what?
have.
Why don't you take my copy?
You have more than...
No, but you can take my copy. We can make a copy.
I have it.
Okay.
Yeah.
Here, then take mine.
I have one.
You have more than one PC?
I have... Mine is from July 22nd.
Tell me who the victim is.
Well,
There's Shader. Then there's Cronus.
This is a theft case. So.
That's what I think you're missing. Then there's Carol. And
I
then
don't
there's
have any
Shader.
named victims, so you must have information that I don't have.
Yeah. So here, you're more than welcome. Take a look at mine. We can make a copy.
Thank you.
Let's recall him. Let's recall him.
Recall? Okay.
Yeah, give Mr. Goldberg time to go through it. Tell you what, while we're doing that, why don't you and I just do some second looks,
Yeah, but
Yes, Judge, no problem.
okay?
Putting down my list on my second.
Let's do the misdemeanors. If anybody's there, let's see. Bruni Desant?
No.
No, okay.
Rudy Desant, he's here? Oh, yeah, he's here. Good morning, Your Honor.
Good morning. He's page 5 of our felony docket.
Yes, Judge.
While you're reading that, Mr. Goldberg, and I tabbed the police reports, 2 of them are duplicates, I believe, okay? For the first one, and then there's, I think the last one are a duplicate. But I tabbed it by the reports.
Judge, I would ask the court just to make a finding as to probable cause.
No, we're on someone else.
Oh, I'm sorry.
I'm giving him an opportunity to read it.
Yeah,
So we're on Bruni Desant on page 5. It's a second
Judge.
look.
He is here present at Maine, and just to refresh the court's recollection, he declined the service of public defender. We asked him again today. He declined the service of public defender, Judge.
I don't remember why he's here again then.
It's apparent that I'm here for case number 18-10-505-CF-10A for battery on officer resisting officer with violence.
No. I know what it's for, sir, but I don't remember what happened when you came the other day.
Oh, well, when I came in the other day, we decided that I was going to get a pretrial release. You put my bond for, I believe, $6,001, which 10% of that was $600. I did not have, you also did a phone order. I was not able to get that phone order. They put me in the infirmary, so they didn't allow me to get my phone nor make a call until like 2 days later.
Okay, and
So
were you
that-
able to make a call?
I was able to make a call.
And what
towards
happened?
I made a call to my mother, and I wasn't aware that it had to be done within a certain time frame. So she said she could do it by Sunday. So I wasn't aware of that. So if it's possible, we could contact her and notify her that it has to be done within a certain time frame, and she's probably able
It
to
doesn't have to be done within a time frame. It's whenever your mother can do it.
Oh, because I thought I was in here for that particular reason, because it wasn't done within a certain time frame.
Well, we were doing it if your mother couldn't pay it, we would address bond, but I have to tell you with these charges, I'm not inclined. Can your mother pay the bond?
It appears she could pay the 10%, but that would be all. And I still would like, if it's possible, if I could get an IRR, because
I'm not
I am
RORing you.
unemployed, and I wasn't aware that the pretrial release that you gave me with, I think I got the second level with the ankle bracelet. I wasn't aware that it was $5 a day. Considering my unemployment status, I don't think I can afford that.
Okay, well, you can talk to pretrial services about that, but that I think is the least of your problems today. I think the big issue for you is getting bond money to get out of jail. Have you spoke to a bondsman?
Yeah, I've spoken to a bondsman.
Okay, and
the bondsman spoken to my mother, and they arranged that they would arrange a meeting on possibly Sunday to pay it off.
okay, well, then we'll reset him for Tuesday, September 4th.
I'm sorry, I don't follow.
We're going to leave your bonds in place and all the terms and conditions, sir.
Until Tuesday? Okay.
Yes,
Thank you so
okay?
much.
Huh?
Thank you so
Afternoon.
much.
Thank you.
I could get this copy.
So really what they're saying is if you bond it out, you're not going to come back until you delete it. But if you have it bond out, then the judge is going to ask questions, going to have another conversation.
Okay.
All right. Good luck.
Okay, let's call another one there. I
Judge,
have
the next
Eric
one-
Rollins.
Oh, I'm sorry. Yes, Judge. Mr. Rollins, come on up.
Page 4, the felony docket. Let's see.
Yeah. Who's this, Your Honor?
Eric Rollins,
For
page
Eric
4.
Rollins.
Oh, this
And then we'll go back to Watson after this.
Okay. Deal with her. Are you dealing with that case? All right, go ahead.
So this is 1,000, 1,000.
This is a second look, yeah.
Hey, I said his bond at 1,000 each. It appears he said he could pay it. Unless you want to correct me, I don't remember.
No, he probably did, Judge. He spoke to his girlfriend, and unfortunately, right now, she didn't have the monetary funds to post a bond. I mean, I know it's the end of the month. They're coming up with rent, and they're supporting their two children, 11 and 13. So he thought, I'm assuming initially we thought he can come up with the $200, the premium with the bondsman, but unfortunately they couldn't. So at this time, we're asking for Your Honor to consider releasing him on pretrial release.
Yeah, we had a case that was no infoed. Tell you what I'll do.
Yes, sir.
Can you afford any bond? It's either that or a GPS. An ankle monitor.
Judge, he has no money, so we're going to be asking for...
Well, when was his last, conviction?
I don't even have, I can't pull it up because it was,
So 2014 you've been clean, except for that one case that you got arrested and they dropped. Judge,
Hold
my
on, they're gonna
understanding-
answer me.
Oh.
I have to do a
That's okay, I think I have it. All right, this is what I'm gonna do. I'll give him the choice. I'll do a GPS, open schedule, or he's gonna have to report twice a month to pretrial, call in 4 times a week. Might be easier with the GPS.
Judge, we'll go with the second option. We appreciate the
Which
court
one?
considering. Second, where standard pretrial reporting in, I believe you said twice a month, and calling in 3 times a week.
I think I said 4, but it doesn't matter. 3 times a week, call in, report twice a month in person. And explain to him, you know, sir, you have to report within 24 hours of your release. If you get arrested, you know, this is gonna be your 3rd shot this year. You'll probably end up on a no bond hold.
Yes, ma'am.
I'm just telling you, okay? Look
Yes,
for your
ma'am.
court date, sir. Good luck to you.
Be there on Tuesday before 12 noon, because we're closed over the weekend and Monday, Memorial Day, no, Labor Day.
Okay, let's recall Cornelius Watson. Do you still have an objection?
Absolutely, Judge.
Okay.
So, Mike, that's Mr. Watson there?
Yep.
Does Mr. Watson need a photo order?
I believe we previously ordered that.
We did do that? Okay.
We can do another one. It doesn't matter.
Well, if photos have been taken. Judge,
He's not sure, that's why. It doesn't matter.
No, he got his picture taken today, or someone from our office went and photographed it today.
Okay.
Judge, from what I can tell from reading the PC, there's going to be 4 alleged victims in this case. Number 1, an unknown vehicle is the first car listed. Number 2 is going to be a Jaguar. Number 3 is going to be a Range Rover, and number 4 is going to be a Jeep. Right? So that's what everyone's seeing?
Well, you went a little fast, but that's okay. I'll trust you on the
Sure,
Jaguar
the
and the
first
rest.
one, he allegedly committed a vehicle burglary and retrieved a Glock handgun.
Tell me the date so I can go to the...
July 22nd, and I believe it's all on July 22nd at different times.
Okay, is this Brianna Shader?
I don't have the list of the victim, but it doesn't say the
second piece.
The first vehicle that is
Second
that is
PC,
broken
okay.
into. But at the vehicle at 7:23.
Okay.
Okay, so based on that, I think that's going to
Where a
be
Glock handgun was stolen.
correct. I think that's count 44, which is the Berg conveyance armed, right? Because he allegedly retrieved a handgun from the vehicle.
Okay, and you have an objection to that?
I have an objection if the court's going to find proof evident on that. I don't have, correct, I don't have a probable cause allegation because it does, a probable cause objection because it does meet the bare bones to find probable cause, but I don't think there's more description here for the court to then find proof evident of an armed burglary and then hold him no bond if that's what the state is going to seek on count 44. If they're not, I don't have a probable cause objection. I just
Well,
have an objection
you
to
agree to
PEPG.
probable cause.
Correct.
You just
I have
don't
an
have...
objection to PEPG.
Okay.
To be held no bond on count
I understand.
44.
It says he's captured on surveillance video.
Unless there's additional information in one of the probable cause affidavits that specifies from the victim that this was a Glock handgun that was taken, then I don't know that that rises to PEPG. To hold him no bond at.
Okay.
I know that it has a bare bones allegation that would meet probable cause.
Well, that might be subject to an evidentiary hearing, a full-blown hearing in front of the judge where the case is assigned. I mean, the basis of probable cause, where it says he's captured on surveillance video, taking a handgun, appears from this vehicle, we feel there's sufficient proof evident and presumption great in order to find him for the court.
I am going to find proof evident presumption great on count 44.
And are you going to hold him no bond, Judge?
We'll talk about that in a little bit.
Okay. The second vehicle, which is the Jaguar, the 2017 Jaguar,
What count are we talking about now?
I believe that's the one that's going to be on count either 52 or 53. It's the same thing. 52 or 53.
All right, let's go with 52, the lower one. So
That's
where
fine.
do you
We
want?
can just go in order.
So
Judge,
where do you want me to go now?
That's count 52. I'm just going chronologically.
I understand.
Judge, the allegation is that he pulled a car door handle of a Jaguar. I don't believe that those actions would constitute burglary of a conveyance. I don't believe that there's a crime that's being committed, period.
Well, I pull on a car door, the court could make a probable cause determination as to an attempted burglary if he didn't enter the vehicle.
I agree for the attempted.
That I would say,
Okay,
Judge,
so-
if you do find there is a crime, then it would be an attempted burglary.
Okay, would you agree with that, Mr.
Yes, Your
Gessler?
Honor.
Okay,
That
so
would be over defense
52,
objection.
I understand. So 52 is PC for attempt only. All right, so let's get rid of 52. Now we're on to 53.
It's going to be 53, which is the Jeep,
Okay, let me go to the Jeep.
the black Jeep, and it's
Hold
going to
on.
be the exact same objection. He allegedly went up and pulled on a driver door handle. I would object to any probable cause being found because I don't believe that those actions would constitute a crime at all. Judge, if you don't accept my argument and are inclined to find probable cause for something,
Now,
I don't
I
know
don't
what
have
the
the
crime
Jeep
would
one.
be. I
Hold
think the
on.
state's going to ask for attempted burglary on that, but I don't know what the crime would be.
I don't have the Jeep.
It's just the next sentence after the Jaguar. The defendant then continued to walk up the driveway and attempted to
Okay, I
enter.
see, okay. So that's for 53? I'm gonna find probable cause for that.
For
Because he
burglary?
attempted. For the attempted burglary of a unoccupied conveyance, unarmed.
I understand, Judge. That would be over defense objection.
Okay,
Then the next vehicle.
Please. I don't mean to interrupt you.
Sure.
But on 53, refers to a different offense report number. That's on the other probable cause affidavit where there's a different victim.
okay, which one's that?
It would be, the victim would be
Cronus?
Mac Neil Carroll.
What is the vehicle?
And the case number is 34-1807-116-737, which corresponds to count 53 on the offense report number on the booking sheet. And then there it says he committed several burglaries where he took a firearm. And that's at a different location than the other probable cause affidavit that the public defender was referring to.
That's for 48. Isn't that for 48?
48, 40, and 57, I believe, are the Range Rover.
No,
Yeah, 48 is the burglary, dwelling, structure, or armed. And the 44 was the Glock.
Right, the unknown vehicle. That least on this.
You're looking at the Matt Carroll one?
Yes, Your Honor.
Because I'm trying to find if there's a burglary. Hold on.
Offense report number on the book, on the.
Yeah, 37 applies here.
Where's the armed burglary with this one?
48's
Oh, no, wait, these are just burglary, conveyance, unoccupied. So
Well,
these,
Well, 48 is an armed burglary, just like 44 is, and I only see one armed burglary, which was the one that we've already discussed on 44.
Yeah, but I'm not worried about those case numbers. I'm right here on the probable cause, on the case numbers on the probable cause.
Are they both armed? That's what they're trying to say.
I think we should start at 40, honestly. Because it's the first one on the booking report. It's offense number 34-1807-116748.
40, I believe, is the same burglary of the Range Rover.
Well, why don't we start from the first one and work our way down?
Sure,
We know the Glock one is 44, at least I believe.
I believe so too.
Okay, but we can always move that number to 48 or whatever number. So let's look for 34-1807. Which police report is that? 116748.
So you know, Judge, that offense number is the same offense number for counts 40, 44, 48, and 57.
Thanks for confusing me before I
I
even
know there's a
found it.
lot, that's why I'm trying to.
All right, I'm just trying to find this one, 116748. Does anybody know where that one is? And there's a corrected booking report, by the way. All right, I think the first case number, I just noticed there's no case number because there is one for the others. This is an offense number. And I believe, if you look at Brianna Shader, the first charge is grand theft. This goes to that first charge, Mr. Dressler. You see that?
Yes, count 40.
That's count 40.
Yes, Your Honor.
Judge, I'm sorry, let me make everyone's life easier. In consultation with Mr. Watson at this time, I'm gonna withdraw, per my client's request, our PC objections at this time.
Okay.
Thank you.
All right, but however, what about 52 and 53, 52 where we found PC for attempt only?
Judge, you do need to set a bond on those counts. Obviously, he's got, I think, literally 50 plus no bond holds. I'm just gonna
I
ask for
understand,
a
but just for
convenience
that
bond
one,
on
since
this
we
case.
did it, Mr. Dressler, 52, you'll agree is attempt only?
Yes, Your Honor.
Okay. All right, so, Mr. Dressler, let me ask you, what are you asking for on,
52 and 53, 5,000 for per account. He's got no bonds on these other counts. I think it's somewhat academic at this point.
No argument from the defense.
All right, so count one is court does find probable cause, 1,000 on 40. 44 is a no bond hold, proof evident, presumption great. He does have a hearing. He's going before Judge Coleman, September 5th. What are we doing with count 48?
Yeah, it's armed, Judge. I would say no bond on that count.
Judge, per my client's request, I'm not going to be contesting that at this time.
Okay, just wanted to make sure. Okay, so 48 is no bond. Then we have 52 and 53 or 5,000. 54 and 55, so then we have 57 is 1,000. You said he has numerous no bond holds, or?
Just before the court,
No, I mean in his other cases. I just want to make a note here. You never know.
Yeah, it's the probable cause affidavit, or the booking report is showing no bond on violations of probation or community control.
Okay, but I'm okay. Oh, it's for VOP. I was asking about before 40, but that's okay. All right, so proof evident presumption grade on 44 and 48. It's without prejudice.
perhaps 50 was hyperbolic, but from what I can see, just scanning it, it's at least 30.
Yeah, his previous cases, he also has no bonds on his previous cases.
Okay. I'll just do without prejudice. Okay. Thank you. Good luck to you, sir.
Jackson Medical, I know you're not feeling well.
Yep.
I think so, yeah. Can I see it? I don't remember
It was
where.
yeah, it was 5,000 each on attempt.
Okay, so clarification, 44 Ivy is no bond, 48 is no bond, 52 and 53 are 5,000 each. And the rest are all staying. So the only ones I did was 44, no bond. So what do you need me to do?
I'll look at it, Your Honor, and I'll let you know.
Okay, well, you better let me know before we leave because. Thank you. Darren Adams?
We did Adams.
Why do I have it again? Oh, I have the corrected.
Yes.
Pardon?
We did it earlier.
So let's delete Darren Adams from the docket. Deshaun Walker, we're getting there.
North Broward judge, he's a medical reset.
That's the one I wrote in.
Yeah.
What page is Walker on here?
13.
He's a medical reset.
Is
Your
it
Honor.
medical?
Yep.
All right. Medical, just put it on top of the other ones over here. Medical is on Walker. Rivera.
Miguel Rivera.
He's here at Maine.
Mr. Rivera, you have grand theft auto, $1,000 bond. Count 2 is resisting an officer obstructing without violence and false ID given to a law enforcement officer. The court does find probable cause. $1,000 bond total is your address, 1401 Grant Street.
Is that your address, sir? Yes? Yes, Judge.
All right, what say you, Mr. Romero?
Judge, I believe Mr. Rivera has a clean record. If he does, we'd be asking a court to consider an ROR.
He's got a 2018 adjudication on a misdemeanor battery. He's got a violation of pretrial release in 2018. He's got adjudication on a misdemeanor assault in 2018.
No ROR.
Judge, hold on one moment. Judge, would Your Honor consider releasing him on pretrial release? He lives locally. He unfortunately just got laid off from his job. So he's asking for the pretrial release, Judge.
No, it says he forcefully brought into the patrol car and attempted to kick the officers, assisting officers. I'm going to leave the bond in place.
Judge, in that case, would you sign a phone order?
Sure. No problem. Kerry Rick?
Mr. Rice?
Rice, I'm
Kerry
sorry.
Rice?
I have some PC objections.
Coming up, Judge.
What?
For Mr. Rice as well.
You have a PC objection?
Several of them, yep.
I'm sure. All right, so Mr. Rice, let me tell you what we have here. Burglary, unoccupied conveyance, unarmed. Hold for magistrate, we need to decide bond. Grand theft between $300 and $5,000. That's a $1,000 bond. Reading off the corrected booking report because I don't know if the top sheet is correct or not. Count 3 is false ID given to a law enforcement officer, $1,000 bond. Count 4 is possession of weapon or ammo by a convicted Florida felon. We need to talk about bond. He has a capious felony for a grand theft, Judge Duffy. No bond hold for 5, 6, 7, and 8. 5 and 6 are capious felonies. 7 and 8 are warrant violation of pretrial felonies. $500 and $1,000 bond signed by Judge Duffy. It's going to court September 5th at 9 a.m. State?
This is on Rice?
Yes.
Okay. We asked the court to find probable cause. The probable cause indicates that the defendant broke into the victim's vehicle, stole a backpack, and apparently an iPad that I guess it appears to have been in the backpack was then traced through Find My Phone to a residence where the subject was at. Apparently the aunt gave consent to enter the residence. When the police entered, it says that the defendant was detained as aunt pushed all the clothing over from, I'm reading down on the PC, over to the side to ensure that the defendant was not hiding there. I'm kind of paraphrasing. Immediately observed a small stainless steel handgun in the same location where the defendant was last standing, shaking off his boxer briefs. Post Miranda, the defendant admitted to purchasing the firearm but did not cooperate with the investigation. Now, The subject has a prior burglary dwelling where he was adjudicated in 2014. Could potentially be possession of firearm by convicted felon. The other issue would be he had an adjudication in 2014 with resisting without violence. He currently has a pending burglary conveyance, 2018, along with a no valid DL. He's got a trespass conviction from 2018, and he has currently filed grand theft for grand theft motor vehicle 2018, and resisting without violence filed in 2018. Yeah, we have a series of, looks like 4 possible case numbers. Or I'm sorry,
He's on.
3 possible case numbers.
Good.
Okay, Judge, as to count 1, there is an allegation that there is a burglary. There's no indication in this probable cause affidavit of how it is that that crime is attributed to Mr. Rice himself, beyond the fact that he is in possession of the iPad that was allegedly stolen. The iPad...
Let's just go one by one if we can, so
Sure.
Mr. Dressler can respond.
Sure, it's count 1. He's in the bedroom that, according to the aunt, he shares with another at least another individual, his cousin. There's no allegation in this probable cause affidavit that anybody observed Mr. Rice inside of this vehicle, or really how it is beyond locating and tracking the tablet to the home, how Mr. Rice is at all attached to that crime. So you have to show not only that a crime was committed, that a tablet was taken from this car, but that it was an individual, Mr. Rice, who did that. And I don't believe you have that here, Judge. I'm not making a probable cause allegation, I keep saying allegation, objection to grand theft, because he's in possession of recently stolen property, but that alone I don't think would rise to probable cause that he committed the burglary. So I'm not raising a PC objection to count 2 because of the presumption. I am asked to count 1, how Mr. Rice committed the alleged burglary.
Judge, as to count 1, the third-degree felony of burglary of a conveyance, the state would ask 72 hours to perfect the probable cause affidavit as to that count. The other counts,
I can raise those to the other
possession
ones.
of firearm by convicted felon, we'd ask the court to find probable cause as to that. The other counts are no bond warrants.
All right, so 72 hours to perfect on count 1.
I'm raising as to count 3 and count 4 as well.
Based
I'm
on
not
the
raising
same
a
reason?
PCL objection to 5 through 8. As to count 3, the false identification of the law enforcement officer, I don't even see that alleged in this probable cause, him allegedly giving a false identification to the officer. And then count 4, possession of a firearm or weapon or firearm by convicted felon. There's no allegation in this probable cause affidavit that he is a convicted felon. I understand the state attorney may have read his record, but there's no allegation before the court in the sworn statements, which is the evidence that he is a felon.
Yeah, where is the, I don't see the false ID given to a law enforcement officer.
Judge, we don't have any problem if the court finds no probable cause on that particular count.
All right, so that one I'll ROR and we'll just,
Yeah, that's okay. It's a second.
Yeah.
Which count is that?
count 3.
Count 3. Counsel's argument relative to the conviction, we'd ask the court to take judicial notice of his convictions relative to Broward County records. Let me see what these case numbers are.
What do you?
Look up his conviction, one of these cases, what is conviction?
Well, he went to prison on 2014.
Yeah, what case number is that? It's case number on the prison case.
Since we're doing this, why don't we just give you time to perfect and they can pull up the record, a certified cop, or, you know, the record, unless you want to do it now.
Well, Judge, the record relative to his conviction, let's see what case number that is, because he has a prison record. Right. 2014, he was adjudicated on a burglary dwelling.
I would object to the court taking judicial notice. I don't have the material before me.
You what?
I don't have the material before me to review.
Yeah, this is what I'm gonna do. I'm gonna give you time to perfect on 4. It's not fair to the defense. So, I'm gonna give you 72 hours on count 4.
There's a problem with that is the officer is going to be looking at an NCIC to base the conviction when the court can take judicial.
That's fine. He can do that too. I'm just saying, since we're doing the 2, why don't we just let the officer just base it off of that, and then this way it'll give the defense time, because they are with judicial notice entitled to be noticed.
Is the public defender saying that his client does not have that conviction? Is that what he's saying?
I'm not disputing it, Judge. What we have is the information before the court. All we have is the representation of the parties. You have a sworn affidavit. I agree with the court that if the officer comes before the court and in his sworn affidavit alleges that Mr. Rice is a convicted felon, I agree that you have reason to find probable cause on that count. That's what I'm saying.
Okay. So just let the officer amend his or supplement his report, whatever he wants to do. So what are we doing with, I missed on number 2. Did we address that, the grand theft?
I have no PC objection to that count.
Okay. So the court finds PC on count 2. This is going to be for Tuesday. And here's the problem. We got to do it at 1 p.m. because he's going before his division judge at 9 a.m.
Judge, when was he arrested? Today.
August 30th, but he does have the no bond holds.
Wouldn't 72 hours?
But he has the no bond holds.
Which would be over Mr. Romero's and my objection. Wouldn't that be Monday? And if anything, Judge, we would ask that this be held. I know the court heard Mr. Romero's argument on that earlier, no later than Sunday. Today is Friday. Tuesday would be 96 hours if my math is right.
I don't really care. It doesn't matter when it is. I was just trying to, you know, be easier about it because he has a no bond hold. But you certainly have the right to object. But for practical purposes, he has a no bond hold. So it's up to you guys. And I'm not scheduling it. I'd do it in the afternoon, even if we did it 9-5. Because I want him to be able to go before his division judge on the no bond holds.
Judge, I'd
rather do this on Sunday.
I would ask that you reschedule this for Sunday for perfection. It's 2 days from today.
Fine. I'll give 48 hours.
That's what count 1 and count 4, Judge?
Count 1 and count 4.
48 hours?
I have to write notes here.
It's FLPD. You gotta send the thing to Dave Agler.
And count 1. You're saying there's no independent evidence or no evidence alleged of defendant being in conveyance since he shares a bedroom with somebody? Is that what you're saying?
There's no.
I'm just trying to give a little bit of guidance to the judge.
I'm arguing that there's insufficient evidence of him committing the burglary to find probable cause.
Bedroom shared where the stolen objects were found?
Correct.
Okay.
Judge, I might bring up one issue, and
Sure.
that is, where if the defendant fails to cooperate after post Miranda,
Sure.
there is a presumption in the statute that possession of recently stolen property gives rise to an inference the person knew or should have known that it was stolen.
Mhm.
So for purposes of probable cause, the court should find probable cause as to the theft.
Correct. I'm not objecting to the grand theft, PC on the theft. I agree with counsel.
We found PC on count 2, but not 1 and 4. Okay, so to make this easy for you, this is reset to 9/2/18 a.m., which is Sunday. And if you could make sure that my notes stay on here, okay? Thank you.
Thank you, Judge.
George Smith.
Mr. Smith's here present at me, Judge.
All right, Mr. Smith, you have possession of MDMA, ecstasy, $1,000 bond. Count 2, drug paraphernalia, possess and or use. Count 3 is a probation violation or community control. That's before Judge Marina Garcia Woods. You're going before your judge September 24th at 8:30 on that charge. The court does find probable cause. $1,000 bond. What say you?
Judge, considering as a no bond hold, nothing to add at this time.
$999 on count 1. All right, let's go to the misdemeanors first. Let's start with the easy ones. We have Jeer Montgomery, page 2 of the misdemeanor second look docket. Jeer Montgomery. He's at the bottom. It's actually Jeremy. They cut off
North
his
Broward,
name.
Judge.
Hello, how are you? All right, so Mr. Montgomery, you have trespassing, occupied structure, $100 bond. We're here for a second look. He's been in jail for 4 days.
Judge, I spoke with Mr. Montgomery, and he would like to resolve if possible. Mr. Montgomery, is that correct? I don't think your microphone is on, that's why I asked the question.
It's right in front of you, sir. It's a little circle, right in the middle.
Yes, ma'am.
There he is.
Do you want to resolve it? You do?
Yes.
Here it is, here it is.
Yeah, but that's their general number. You transfer all around. This guy's the patrol guy. You never get him. I'm gonna send a email to Dave Agler.
Okay.
Okay, this is a mobile 7-Eleven. said that he was causing a disturbance in the store, the 7-Eleven mobile. Mr. Dressler.
Trespass.
Adjudication time served.
That's fine, Your Honor.
Sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, thanks, bye.
Is your name Jeremy Joseph Montgomery, Montgomery?
Yes, ma'am.
All right, put your hand down. Mr. Montgomery, it's my understanding through your attorney, Mr. Goldberg, who's sitting in the courtroom with me today, that you wish to resolve your case?
Yes, ma'am, I do.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
Just medication for psych.
Okay, does your medication affect your ability to understand what's going on here today?
No, ma'am, it does not.
All right, because you look a little tired, and I just want to make sure that you're doing this freely and knowingly and voluntarily. So you don't have an issue with that? You understand what's going on?
I do understand, yes.
All right, okay.
I apologize.
That's all right. You don't have to apologize. All right, so Mr. Montgomery, have you ever been treated for a mental illness?
Yes.
Does your mental illness affect your ability to understand what's going on here today?
No, it does not.
Okay, so how do you want to plead? Guilty, not guilty, no contest. 2, trespassing in a structure or conveyance.
No contest.
And you've had enough of time to talk to your attorney, Mr. Goldberg, who's in the courtroom with me?
Yes, I have.
Do you feel that pleading no contest is in your best interest?
Yes, ma'am, I do.
All right, you know that you can't go back to this mobile 7-Eleven at 1799 North University Drive and Plantation. If you go back there, you'll be arrested.
Understand, yes, ma'am.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication time served. Do you need a place to live?
I'm planning on going back to the Florida Sober House in Hollywood. My
Okay.
family's going to help me get to.
Okay, so adjudication time served, $293 in court cost. You have 1 year, I'll give you, to pay your court costs. If you don't pay them, they'll suspend your driver's license, give you a $25 late fee, and it'll affect your credit. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed, and partial payments are accepted as always. Thank you. Good luck to you, sir.
Thank you. Yes, ma'am. Good luck. Thank you.
There's Brenda Trochez is the last one on that docket, on the top of page 2.
What about, no, but we have Jermaine Monteith.
Oh, I'm sorry, I thought we did Mr. Monteith.
Did we?
I don't.
Let me see. No, I don't have it. That's me. So let's go Brenda Trochez.
She's in Paul Ryan Judge.
Hello. Hello. All right, Ms. Trochez, you have petty theft, second degree, $99 bond. That means she has something else going on. Maybe that was resolved.
She did, Judge, but she had a probation, but she resolved that matter and has been reinstated, so it's just this case that's holding her on a $99 bond. She has advised me that because it's a low amount that she's having difficulty finding a bondsman to post that. I'm going to ask if she could be released on her own recognizance or placed on pretrial release on count 1.
I don't have a problem with an ROR as long as she'll come back. She doesn't, then she'll get arrested again on the same charge.
Ms. Trochez,
she's on probation now?
Yeah, that's fine.
Is she on probation?
She's being supervised.
Yeah, I got reinstated.
Let me go off the record for a moment. Wrestler, I'm inclined. She's on supervision with the Department of Corrections.
Yep.
Yes,
She's
Your
on
Honor.
supervision with the Department of Corrections, so I'm inclined to ROR her on this petty theft. She was held no bond. Okay, so ROR for Brenda Trochez.
Thank you, Judge.
That's page 2 of the misdemeanor docket, Mr. Dressler, okay?
Yes, sir.
Or Kifa, who's ever keeping track. All right, thank you.
Thank you, Your Honor.
All right, let's finish our misdemeanor docket. Jermaine Monteith.
Mr. Monteith is here, Judge at Maine.
Let's see. All right, he has $1,000 bond and pretrial supervision. Let me look at this case. This is just a regular. I have $2,000 bond, and then we went down to 1. It says 1,000. What do you have, Ivy? Yep. All right, so it's 2,000. Maybe you can talk to him about a program or something like that. If he doesn't want to bond with the GPS, something needs to be.
Well, he has a place to reside. He can reside with his sister in Lauderdale Lakes, Judge. It's just he doesn't have the financial ability to post that bond.
There's a no contact order with minors. You know what? Let him go before his division judge. I'm going to deny it without prejudice. Have someone file a motion with Judge Solomon. Thank you. Okay, so we finished the misdemeanor docket. Just sign these orders. Give me just one moment.
No problem, Judge.
Who is that, Mr. Romero?
This is Mr. Madison, which is going to be extremely quick.
Thank you, Judge. I mean, Mr. Romero.
Extremely what?
Quick.
Sharif Madison on the bottom of page 4.
Sorry, where is this? Page 4? And then we're going to start at the top. Okay, Sharif Madison.
Yes, Judge.
$100 bond.
He has a child support hold right now, so no matter what we do on this case, his family's still coming up with the child support, so I'd ask you to impose a $1 bond. Or leave
It was resolved.
It was resolved.
His child support? They did. Someone paid your child support. The purge amount. Okay. So I guess there's more to it, Judge. Let me inquire.
It was resolved? It's still showing.
Are you sure?
Madison.
Oh, by a judge?
Great.
So what's the bond on this case?
$100.
So he can't bond.
Did they pay it? Or Judge Frink just said he's allowed out and...
Yeah, he just ordered him to be released. And he vacated the file, the civil charge.
In that case,
he should be able to pay the $100.
Yeah, I paid $100. Yeah, that wasn't the problem. That's why I thought it was going to be simple. All right, so if that's taken care of, you can post bond, right?
Okay, so we'll delete it.
Okay.
Okay.
I have two others that we could delete.
No, it's not all 30, this is just.
All right, go ahead.
John Aguirre, come on up. Judge, he managed to get in touch with his family. His family's gonna post his bond. I just want this to make sure it doesn't fall through the cracks. Can we reset it for Tuesday? If he's bonded, it'll be
Here's
deleted
the
on
thing.
Tuesday.
I just want you to know the other day I got an email from Sheila saying, because we reset somebody, it was a House of Hope, or I don't know, they were going to one of these drug rehabs, and I had to send an email to take it off the docket, because otherwise they wouldn't release them, custody to custody. I just want you to know.
Okay, but here, his family's gonna be posting his bond.
Okay.
So therefore, because they're gonna be posting his bond, he's gonna be released today. So if he's released, then we have nothing
They're
to
gonna
worry
do
about.
$1,000, right?
Yes. I'm just saying if we could
Let's
go ahead
reset for Tuesday
for
at 1
Tuesday.
p.m.
Thank you, Judge.
No
Thank you,
problem.
Judge.
Can we do that?
And
Who's this for? Here?
John Aguirre.
John
on
Aguirre, page 6.
Reset.
Yes. Here it is.
okay, so if you bond out, don't worry about Tuesday. If you haven't bonded out, on Tuesday we'll make a request to the judge, okay?
Where's my
Good.
shoe? Okay.
And Miguel Forrest is the same exact issue. He managed to get in touch with his family.
What page?
Page 7.
Miguel Forrest.
Page
Miguel
7.
Forrest.
Same thing.
You're too fast for me
Contacted his
today.
family, and his family's posting his bond. But just in case something happens, we'll reset it for Tuesday.
Sure. Is it posted yet? Defendant, family posted. So let's reset to Tuesday. What is Tuesday, the 4th? Yes. 9/4/18 at 1 p.m.
Perfect. All right. So good luck. Hopefully your family comes through today.
They definitely said they're paying, right?
Yes, Judge.
All right, let's start. At the top, I think we only have a couple left. Carlton Creek.
He is
Bonded, Your Honor?
out of custody. Out of custody.
So he bonded.
My notes just say out of custody, Judge.
Yep.
It says 1,000 in Elmo. Is that confirmed? Huh?
Yes, Your Honor.
Released? Okay. Bernard Davis.
Bernard Davis. Oh, Bernard, Paul Fine, he's on the 30-40 day docket.
Oh, okay.
Okay, Paul Ryan.
Hey, how you doing?
Hi, your name is Bernard Davis?
Yes, ma'am.
All right. Your attorney filed a motion for you to be released, sir.
Yes, ma'am.
The state attorney has until today to file formal charges. State didn't file formal charges. We're going to ROR you. This is on the possession of MDMA, ecstasy, false ID given to a law enforcement, and resist or obstruct without violence. But let me just tell you, that's the good news. You're going to be released unless you have other charges pending. But that doesn't mean in the future that the judge can, he has nothing else pending?
No, he does. He does have something.
What does he have?
He has the warrant, pre-trial warrant, unlaw use false name identity.
When was that issued? Was that served on him?
He was arrested on it on July 29th. This is a pre-trial warrant.
Okay, yeah, I just want to make sure it was served on him. He's not just sitting in there waiting. Okay. And what, does he have a hearing date? What's that case number?
18,
Yep.
46, 06 MMA with Judge Mann. Unlaw use of false identity.
So he's here on a pre-trial warrant, and it's not in her mental health division. Does he have a pending violation in a felony case? There was a motion filed for reconsideration August 31st. Saying he's gonna be under the supervision of the drug court. Right, you're gonna have to look into it. I don't know
That's
what's,
the new law that's he's being released on.
what?
The possession of MDMA, false ID, and resisting, that's tracking in Judge Tobin-Singer's division, which
Yeah.
is drug court.
All right, well, you might want to address it again. There's a motion for reconsideration that was just filed.
On the misdemeanor.
Yeah, because that's what's holding him.
Right.
That's a no bond hold, or what's the bond? $500 in Judge Wren.
500 on each count, so it's 1,000 total, Mr. Davis.
All right, so sir, the good news is on this case, you're going to be released. I told Mr. Goldberg who he's going to contact the public defender in Judge Wren's division, and I guess they'll come and talk to you, or
What if I wanted to get time served on that case?
on which case?
Judge, would you consider resolving that matter before the court today? It's case number 18004606 MM10A.
I don't have a problem with resolving them. It's a trespass and a false ID.
And a false name, yes.
State, do you have an offer?
Judge, I don't have a file on this.
Judge,
I'm not able to make an offer, I just recommend.
Hold on one moment.
Division judge.
He was in Wawa, panhandling. He didn't give him his name. They had to use a fingerprint scanner. Had a warrant. He was charged with trespassing and providing a false name. Yes, sir.
if we resolve, I have to get the dispo from downstairs, from out of that division.
Well, you
If we're
can.
gonna solve it, if you go, I'm gonna call for it.
Do you want to resolve it?
Yes, ma'am.
Yeah,
Okay.
Judge, there's no restitution, there's no violence.
What's the case number again?
Sure, the case number is, oh, I just clicked the wrong thing. 18004606 MM10A. Count 1 is an unlawful use of a false name. Count 2 is a trespass.
All right, so sir, let me just finish with this MDMA thing. So just because I'm releasing you on your own recognizance doesn't mean that the state attorney is not going to file charges in the future. Okay, they have a certain amount of time. You can discuss that with Mr. Goldberg if you want, or another public defender. So you have to keep your address current, and you have to, you can go to any clerk of court. You can also, you have to do it in writing. You can come to the clerk of the court in any of the 4 courthouses, Plantation, Hollywood, the main courthouse, or Deerfield. And you go there and you tell them your name and you want to update your address, okay? You can also contact your public defender, or you can always come to the courthouse and speak to them at the main courthouse, okay? They'll be more than happy to help you. So that's just on the MDMA false ID given to the Leo. So, State, do you have a recommendation on this case?
Yes, Judge, 90 days probation, adjudication.
Okay, the only thing is I don't put them on probation in here.
All right. Reason why I'm saying that is on the MDMA, all we're waiting for now is the BSO lab result. Once that happens, the case will get filed if it comes back positive.
Okay, that's fine. So on this case, would the state be agreeable to an adjudication, time served, no return to the Wawa? Because he can be put on probation. I don't know what's gonna happen with the state case.
Judge, that's, I'm sorry.
Like I said, it's gonna get filed if it comes back positive on the drug lab.
Okay.
We're just gonna defer to the court.
Judge, we were asking for an adjudication, time served.
Okay, does your client understand it's $293 in court costs, and if he doesn't pay that, that his driver's license will be suspended if you're caught driving while your license is suspended? If you don't pay the $293, sir, then you're gonna have a $25 late fee. It's also gonna affect your credit. Do you understand that?
Yes, ma'am.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Bernard Davis, D-A-V-I-S?
Miss Hernard, H-E-R.
Sorry, I'm sorry. H-E-R-N-A-R-D, Davis, D-A-V-I-S. It's been a long day.
Yes, ma'am. Yes, ma'am.
Okay. All right, Mr. Davis, your attorney, Mr. Goldberg, has told me that you want to resolve your case today and give up your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
All right, does your mental illness affect your ability to understand what's going on here today?
No, ma'am.
Okay, so you understand that I could release you on these charges if I wanted to, and you could come back and fight them. Do you understand that?
Yes,
But
ma'am.
you still want to resolve them today, correct?
Yes, ma'am.
All right, so how do you want to plead to false ID given to a Leo, trespassing, unoccupied structure, or conveyance? Guilty, not guilty, no contest.
No contest.
You understand that if you go back to this Wawa, you can be arrested, sir.
Yes, ma'am.
Okay, and you agree not to go back there?
Yes, ma'am.
Okay, and you know which Wawa I'm talking about, right?
Yes, ma'am.
All right, court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. So adjudicate and time served on each count. On count 1, $293 in court costs. I'll give him 6 months to pay. Partial payments are accepted. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. No return to the Wawa, sir. I'm serious. You'll be arrested, okay?
Yes, ma'am.
Thank you.
Thank you too, miss.
Good luck to you.
Yes, ma'am.
And you have that case number, right? Okay. You need the charges? Here you go.
No, they bring me the dispo.
Okay. Thank you. All right, so. Then we're on page 3. Nathan Kemp. Where is he?
Did we do Miss Keat on page 2?
All right, maybe I missed it. Let me go back to it.
Yeah.
Page 1.
2.
Yes, ROR. State has not filed charges.
Ingemar Keat?
Yes.
Ingemar Keat. It was an ROR. State didn't file charges. You were on the phone, so.
Thank you.
Nathan Kemp, we didn't think you'd have an objection.
I don't.
Nathan Kemp.
Yes, ma'am.
Okay, this is an ROR motion too. This is a felony battery, domestic violence, a third-degree felony, resisting an officer, obstructing with violence. State, has there been formal charges that have been filed?
I think it's going down to a misdemeanor, but he's entitled for an ROR on these felony cases, Your Honor.
Okay, so per the state, ROR, you're gonna be released on your own recognizance on these. However, it's my understanding that they're gonna file these as a misdemeanor. So you're gonna have to update your address if you move with the public defender's office and the clerk of the court. Do you understand?
Yes, ma'am.
The case is filed as a misdemeanor also. So it's not going to.
Okay, sir, you're free to go if you don't have anything else pending. Good luck to you.
Thank you, ma'am.
Oh, sir, I am going to say one thing. You are to have no victim contact, direct or indirect. And all those original terms and conditions still stay in place. Do you understand?
Yes, ma'am.
All right, thank you.
Ma'am, quick question. That means I'm going to be on pretrial?
No, you're going to be
just-
released.
okay.
But
All
you're
right.
not allowed to have victim contact.
All right, ma'am.
Okay?
Yes, ma'am.
Thank you. Good luck to you. Kevin Suku. Hello, sir. You're here for a motion for ROR, tamper with or fabricate evidence, possession of cannabis less than 20 grams, resisting an officer or obstructing without violence.
Yes, ma'am.
I'm waiting to see, your attorney filed a motion to have your case, to allow you to be released ROR. We have to see if the state filed formal charges by today.
The tampering was declined and the misdemeanor stayed, so he's entitled to an ROR on that case.
Okay, so we'll ROR them on 2 and 3. So, sir, they're still gonna keep the possession of cannabis and the resisting an officer without violence. Does he want to resolve it? Did they file it or no? Actually, on magistrate court, I can resolve it if I want.
I just resolved it today.
Our email shows it's been filed.
Well, we can resolve it I'm just saying if we want.
I see
You wanna...
it. Case 18-008383 MM10A.
8383?
Yes, Your Honor. Count 1, possession of cannabis. Count 2, resisting without violence.
You need more water?
I'm okay, Judge.
Do we have more water?
No, I'm all right, thank you.
Okay, we want you to last till the end.
All right, thanks.
Okay. All right, so usually on the count 1, because of a driver's license, we usually do a withhold. And, I mean, the possession of cannabis under 20 grams. And the count 3 would be an adjudication, time served. Is that okay with you, Mr. Dressler?
Yes, Your Honor.
Okay. Is that what he wants to do?
Sir?
Okay, raise your right hand. Do you want to resolve your cases today?
Yes, ma'am.
All right, you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Kevin Sokoo, Sookoo?
Yes, ma'am.
All right, sir. In case number 18-8383-MM10A, it's my understanding you wish to resolve your case today of possession of cannabis under 20 grams and resisting an officer without violence?
Yes, ma'am.
Okay, is anybody forcing you to do this?
No, ma'am.
Okay, you need more time to talk to your attorney, Mr. Goldberg, who's in the courtroom with me?
No, ma'am.
Okay, you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, you understand, if you want, you can be ROR'd on these 2 charges today. You don't have to admit to them and plead guilty or no contest. I'll release you on your own recognizance. So, do you want...
I will be released?
You're going to be released either way today. This is my question. If you want to be released on your own recognizance and come back and fight these charges, you can. You can have your day in court and have a trial. But if you want to resolve your cases today, then you can plead guilty or no contest. In other words...
I'd like to resolve them, ma'am.
Okay, that's what I thought. That's what I wanted to know. All right. So you're going to plead no contest?
Yes, ma'am.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Withhold of adjudication on the possession of cannabis, 308, I'm sorry, not 293 in court costs. I'll give you 6 months to pay that. If you don't pay it, sir, they'll suspend your driver's license and you'll get a $25 late fee. And if you're caught driving while your license is suspended, then you're going to be arrested for that, okay? So make sure you pay it. It also can affect your credit. So withhold of adjudication and court costs of 308 on 1, partial payments, obviously, and adjudication and time served on the resisting without violence. Court takes judicial notice of a time that Mr. Sokoo has served on count 1. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
So
you're done with...
Was the tampering declined and the only thing that was filed was counts 2 and 3?
Yes.
Okay.
So
okay.
RL for count 1 is RR for the tampering.
Correct.
And as far as for count 2, Judge, is it court cost or you looking for court?
No, 308.
For the possession of cannabis?
Yeah, withhold.
And the other one that you adjudicated on?
Yeah. No. I only need to do it on 1 in each case.
Okay.
Speak to Jeff Bauer. He'll tell you. All right, thank you, sir. You're done, except pay your 308. You don't want your license suspended. You have 6 months. You can make partial payments. You can go to any courthouse, okay?
Okay, thank you, ma'am.
You see it?
Is declined for the tampering, and the possession and the resisting are the case number 18. I did an order. It's declined. He's going to be ROR'd on it. Okay? 3 counts are on it, right?
Yes,
And you have ROR
for count one,
for count one.
which is a temper. Count two and, well, the misdemeanor. she
Counts
just
2 and
resolved
3, he pled out, so he's released. You're welcome.
that. Can I get a proud on that, Judge, with the case number, please?
Absolutely. What's give me the number again?
I think it was the 188383 MM10A.
And then I'm gonna run out of here.
Someone is coming in.
Oh,
Okay.
it's a discipline.
All right.
She's putting it out.
I was like, this is gonna be a problem. Usually attorneys walk in looking for something on a Friday. Jackie, you're supposed to lock the door. I'm only teasing. Here you go. Hi.
How are you?
Good. Okay, so Yagu Aviles says bonded with a question mark. AVILEZ. He bonded? Excellent. Aviles, Yago Aviles.
I know in the case he was released.
Who's next? The son?
Who do you have there?
Mr. Robert Lewis?
Okay, let's
Come
call
on
him.
up, sir. Judge, he's being held on a burglary of unoccupied conveyance. Your Honor, release him on Elmo. He's been in since the 28th. Unfortunately, he does not have a place to stay, Judge. We're going to be requesting that you release him on standard pretrial release.
For me to put someone on an Elmo. Let me see. What's his prior history, State?
I'm gonna check right now and see.
Oh, this is the one where they had the canine and they saw him breaking into the car. Where does he live?
Few places. Judge, he doesn't. He basically goes to different friends. I'm assuming sleeps on their couches, but nothing, no stable residence, Judge. I know, Your Honor, last time the state did mention he had a record. However,
He has
my
a
understanding,
long list of since 2015.
but I believe he's been clean for about a year. Or he's telling me now more than a year.
More than. Criminal history is or
You know what? He's out stealing. I don't know what his sentence was in 2015.
One case we're looking at here, it looks like he was sentenced on some type of credit card crimes, and he had a probation violation or community control violation on 157896 CF10A.
I mean, it doesn't sound like he really has a steady employment or a place to live. Why doesn't he go to, I don't know, what's the name?
CRC?
No, the sober house. Or, I don't care where it is, I'm just saying that place where they, I don't know, Pompano something, not the beginners, the sober house there. First Step Sober or whatever it is.
Well, Judge, one thing, Your Honor, suggestion as far as on pretrial, you can release him on standard pretrial and he could be reporting once every week in person.
But here's the thing, when he doesn't have a place to live, he's out stealing in cars to make money. And I know this is just an allegation, and, you know, he has a long history. I know it's from 2015. I don't know when he was sentenced in the 15 case. He could just have got out of prison or jail a year ago. I don't know. State, can you tell me? Ms. Patrice?
He got released out of prison, I believe
Robert
it was been
Lewis.
over a year.
You've been awfully quiet today. Ms. Patrice?
Judge, our safe system, we're having a little issue with right
That's all right. Ms. Patrice will look it up. I mean, so if he has a place to live, then why can't he verify a place to live?
Because he doesn't have a set place. He goes to different locations, different friends. No one's going to say, yes, he's going to be here, living here for the next 6 months or something like that. So that's why I was going to suggest to the court, have him on pretrial and have him more stringent, basically conditions.
Okay, I'm not going to do it. I just, in this case, I'm not going to do it. Let him find a program or a place to live. If he wants to live a place for a month and then get a job and find a place on his own, that's fine, but he has a lengthy history.
His most recent release from Florida State Prison was July 9th of 2017.
Oh, that's why he hasn't had a.
Yeah.
For 1 year.
All right, let him find if you want, I'll reset him. He can look for a place over the weekend. I can reset him or deny it. What would you like?
That's the one, it's not for R1 or anything. This is just the second look.
And just so you know, we did interview him more than once. He gave us a couple names and numbers.
And?
Whenever we called and told them why, they hung up and never responded.
I mean, does he need help with names? I know Mr. Sanders has a lengthy list. He has it all mapped out. He's really done a lot of work.
Yes, I do need a list. There's nothing here. I have no places to look, no phone numbers to call. I have nothing like that.
All right, so Mr. Goldberg, can you have someone send him over a list and we'll reset him for Tuesday?
Sure. He wouldn't.
You don't want to?
No, of course, we're happy to help. He's our client.
Okay, let's go off the record for a second.
Sure.
Okay, so someone's going to be in touch with you or send you something. We're going to set you, Mr. Lewis, reset you for 9/4 at
You're so close. We have like 2 more to go.
I don't.
1 p.m.
I can't represent to Your Honor that he'll be seen before September 4th.
Well, you know what? He can ask other people in the jail too. He could talk to them about sober lit. I don't know what's the name of that place.
Well, will these be places where I stay there and I go to work and
You're
go
gonna be
AA
court ordered to
meetings?
stay there and you have to pay them to live there.
Yes.
It's very affordable though.
And I'll go to work and I'll go to AA meetings, right?
Yeah.
Yes, I understand. All right, thank you, ma'am.
Okay, I'll agree to do that, but you're gonna be court ordered. You can't go there and say, I ain't staying here and I'm leaving. Can't do that.
I understand. I understand.
Okay?
Thank you, ma'am.
You're welcome. All right, so we'll reset you for Tuesday at 1 o'clock. Thank you.
Yes,
Talk
Mr.
to other
Johnson.
people in the jail in the meantime, sir.
Talk to other people, sir. Mr. Johnson's here. Judge.
Hold on a second. What? Okay, Curtis Johnson?
Similar situation, I believe Your Honor released them on Elmo, and unfortunately at this time there was nobody that could basically say or verify the address that he could stay there. So Judge, we're gonna be requesting standard pretrial release on Mr. Johnson's behalf. I will say this, he has something else going for him. He is working and he doesn't wanna lose his employment, and he advised if he's able to be released, then he'll be able to keep his employment. And where are you working, sir?
For J&J and contractor.
It's a contracting business, Judge, that they have, I guess, some sort of client and that there's work, and if he's able to be released, he'll be able to be employed.
Based on the notes in our system, it said that he told us that he can live with his mother, Joanne Redhead, and he gave us her phone number and address. We contacted his mother. She informed us that the client is quote-unquote homeless. We then asked her if she would allow him to just live there for a while. And she stated, quote, he cannot. I've been through too much with him and I can't do it anymore. I am tired. Furthermore, she says that she is the one who's responsible for the defendant's 2-year-old child. She said at this point he is quote unquote better inside than out because Your Honor, she doesn't want to do anything to take him in that would jeopardize her having to lose the grandchild.
Stealing cartons of Newport. Oh, this was the one with the 27 cents. Prior history, Ms. Patrice.
There's a lot of priors, Your Honor. The last one before this was August 16th.
For what?
Trespass. Before that.
Okay, he's another one that needs to find a place if he wants. I don't know if it's a drug issue or a housing issue, but he has a 2016, a case in August. And then I think there was another one. There was a couple this year, weren't there?
I believe so, Your Honor.
Yeah. So I did no bond, it's just an Elmo. I'm not gonna do pretrial release, I apologize. So we'll reset you if you want. You can look around for a place to live. You can ask other people in the jail. You're gonna have to find a place to live and work. We can reset them or deny the motion. I'll reset them till Monday. Tuesday.
I'm gonna look for a job.
You don't look for a job while you're in jail. You
I
go.
already have a job. That's what I'm saying. I just got this job.
Sir, you know what? You have a charge, and I'm not going to argue with you. I know these are only allegations, but you have a couple charges this year. So, that's the reason for this, and I already gave you a break by doing no bond. And you have no place to live, So the only thing I can tell you is if you want to find a place to live, I don't know if alcohol or drugs are your problem, or if they're not, then you can find another place. We can reset this for September 4th, which is Tuesday at 1 p.m. if you'd like. Speak to other people in the jail. What would you like to do?
So So what's she saying, man?
Let me explain.
Yes, sir.
Knowing that for this case, what are the charges at? Because it was just found
Possession
today.
of cannabis under 20 grams and resisting without violence.
Okay, so I need to write that on the
Where?
dispo.
Here?
It's count one. It's the possession of cannabis, 20 grams of lead.
All right, Judge, we'll reset it for Tuesday. He's gonna try and make some calls.
Yeah, for Tuesday.
Thank you, Judge.
I believe so. I don't see any more after this. What's left?
Is that it?
I don't know. I don't know if we have this one left.
Okay, so this one's a withhold,
Yeah, count, which is count.
and it's 308 in court cost partial payments.
We have one more left.
See you on Tuesday, Judge.
Have a wonderful weekend.
Same to y'all.
Hey, great
Where was
news for
Suku? Was he
everybody.
in the, that was you, right?
Yeah, Mr. Bondin is no longer in custody.
Oh, he bonded? Okay, so
Yeah.
that's it then,
Oh.
right?
Mr. Bondin on page 6.
Okay, there you go, you can just,
So we're done with everything?
hold on. Mr. Bondin bonded.
Earlier today, he was released. He was not released this morning when I looked at it, or this afternoon, but he's released as I'm speaking.
Isn't this list the coolest thing? You know who does that is Miss Monteith. I'm gonna send her an email to send stuff to you.
Please.
We're done, right, Your Honor?
Huh?
We're done?
Thank you so much.
Thank you. Have a good weekend, everybody.
You too. Tell everybody they owe you.